Court, all rise. Hey, 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 all present, and the people in the Justice of the Appeals Court of Boston, draw near, give your attendance, and we shall hear. God save the Commonwealth of Massachusetts. This court is now open.
Good morning, everyone. My name is Vicki Henry. I'll be your panel chief today for this May 4th, 2023 sitting of the Appeals Court. I use she, her pronouns. You are welcome to share your pronouns with us. I am delighted to be joined today by Ken Desmond, who uses he, him pronouns on my right, and John Englander on my left. We have 5 cases on today. We'll hear 3, and then we'll take a short mid-morning break. Each side has 15 minutes, for better or for worse. We do not have rebuttal in the appeals court, so give us your best shot in your argument. I assure you that we have read your materials carefully and are familiar, particularly with the facts of the case. So I'd encourage you to use your time to focus on the legal arguments. And with that, I will call the first case, which is 2022 P552, Commonwealth versus Alfonso.
Good morning, Your Honors, and may it please the Court. If it pleases the Court, I'd like to start in the order of my brief. The first thing I would like to discuss with you this morning is the closing argument of the Commonwealth, in essence, when they state, among other things, that but you don't just have 50%, you have the other 50%. And why is that important? It's important because right off the bat, the jury hears a different version or a different version of beyond a reasonable doubt. So you have the identification, which is 50%, and the Commonwealth, at least the way I read it, and when you listen to the audio, is they're almost given each piece of evidence is worth X amount of points. Okay, so you have the identification is worth 50%, the victim's testimony is worth whatever amount, pictures are worth this amount, and this is worth this amount. So if you have 100 pieces of evidence, is each one worth 1%? That's kind of the way I started to look at this case.
So, counsel, I suspect the Commonwealth will get up and argue that she didn't do this in association with the definition of reasonable doubt, but she did it because he said he was 50% sure of the identification, and she was just using that number, and so the jury would have understood that, and therefore there's no issue here. What do you say to that?
I agree with parts of that. The part I agree with is obviously the identification is what it is. The victim took the stand and said he was 50% sure of the defendant being that person. But why it's important or different is, and I think the cases through the appeals court and the SIC are fairly clear in that both the defendant and the prosecution just stay away from saying anything really about beyond reasonable doubt, other than, ladies and gentlemen of the jury, I proved in this case beyond a reasonable doubt or something.
You know, there's a decision by Justice Lowy from less than 2 years ago that doesn't say that.
I'm sorry, I didn't hear you.
It doesn't say stay away from arguing beyond a reasonable doubt. And I have to say, my own instinct would be, why? It's the elephant in the room. It's the most important thing in a criminal case, the burden of proof, especially for a criminal defendant. Shouldn't people be able to argue about it as long as they hew to what the instruction of the judge will be? I mean, that's what Justice Lowy said in this decision 2 years ago. He didn't say stay away from it. Well, he actually said this argument was not error.
Oh, let me rephrase it. You were correct. Let me rephrase what I'm trying to say. I think what the courts are trying to say is don't, I think, quantify it. And, is beyond a reasonable doubt, is it 100%? Is it 80%? Is it 70%? We don't know. It's kind of like you go to the jury, and it's not all reasonable doubt. It's some reasonable doubt.
Do you think it's per se reversible error? Is that what you're saying?
Well, the defendant did not object, so it is a substantial miscarriage of justice standard. So I do concede that. It is what it is.
And so it may be better practice to stay away from it, but it doesn't automatically result in reversal, right?
No, I would agree the burden in, especially this case, is much higher because the defense attorney missed the objection or didn't object for whatever reason. We unfortunately don't know.
We can speculate why they didn't object, right?
I guess we could speculate. I mean, I'm sure you know what it's like. You're in a trial and a million things going on, but would I like
Also,
to...
the statement equates beyond a reasonable doubt with 100%, which defense counsel might have been very comfortable with.
Perhaps. I'm not going to argue what could or could not have happened. I don't know. I mean, I do believe that both sides, especially the Commonwealth, should not be saying, we have proven it by 100%, and this is the 100%, and here it is. And I think one of the cases that's pretty close to this case, cited in my brief, is Commonwealth versus Ferreira. It's a little bit different in that they did like an actual mathematical equation in that case. This one's a little bit different. They don't do an actual mathematical equation, but it reads as though the Commonwealth is saying, here's the evidence and here's what everything is worth to you.
So how would this amount to a substantial risk of a miscarriage of justice where the defendant's license plate was found at the scene of one of the car crashes, and the victim did in fact pick him out of a lineup, and even though he was clearly worried about like picking out a stranger, he said this was a near perfect visual representation of the defendant?
Okay. I was kind of waiting for that question. Your Honor, the reason why I believe it's a substantial miscarriage of justice is, yes, he did identify him. And the judge believed at the very beginning of this trial, they have tried to do a Creighton motion, say they should be able to identify the defendant at trial. He said it's unequivocal. So right off the bat, the jury's not going to know unequivocally that is the identification. And yes, there was some evidence of the license plate and some other evidence, but that still doesn't give the Commonwealth a blank check to say, I don't mean to say the same thing over and over again, a blank check to say each piece of evidence is worth X amount of points.
Right. So were there pictures of the defendant's car in evidence?
Yes, there were a bunch of pictures, and I believe there was a video after the fact where they showed the license plate, and I think there's a McDonald's parking lot.
Of the defendant's car. The question was whether there was video of the defendant's car.
Or photographs?
Oh, no, there was, because I guess, it's almost like a road, I guess you would describe this as a road rage case, is the
Right.
best way I would describe it. There's no video of the defendant's car, no.
No, but even photographs. I mean, did they ever come up with the defendant's car? Because it would have,
No.
okay.
No. That's not, I guess there's other issues I wish I could have talked about, but it is what it is.
Okay. On a different point, the Commonwealth argues that the issue of whether the defendant placed the victim in fear was an element of assault with a dangerous weapon. I wanted to know what you said about that.
I don't really have much to really say about that.
I mean, do you agree with that?
Yes.
Yes, okay. You had argued that the prosecution stated facts not in evidence in the closing, but I was not clear what specific facts those were.
Okay. So, part of my brief, I state that they insert their opinion and facts not in evidence. So one of the things that they state in the evidence, I mean, in the closing, I'm sorry, is they say, it's almost off the beaten path. He says, quote, I actually think he said that he didn't look at any cool police stuff in the car. He didn't look at the photos. I read that transcript, I can't tell you how many times. I did not see that. Is it the most egregious error? No. I'll agree that's not the most egregious error. But I do believe when you look at the first error, which I'm stating in the mathematical equation, the evidence, a statement that was not in evidence, as well as inserting your personal belief, I think that starts to get you over the hump because we have more than one error. If it was just one, I guess, fleeting statement, it's probably not really there.
Counsel, he did testify that he did not look at the screen, right?
Correct. That was, yes.
It's the cool police stuff that you're objecting to, saying was not in the record?
Maybe. I mean, I didn't really see it that way, but maybe.
Maybe what?
Maybe that's
what you're objecting to?
No, I'm sorry. Maybe that's what he was talking about, but I didn't view it that way.
That's not what I meant. What I meant was, I'm concerned, what is it that you say was a argument about facts not in evidence? It's not that he said he didn't look at it, which is the way the prosecutor ends that paragraph. It's I think he said he didn't really look at the cool police stuff. Is that the statement you're objecting to?
Yes, Your Honor.
But isn't that just argument?
It's just argument.
I mean, we have to give some room for argument, right?
Yes, I would agree, I mean, it was just very strange the way it came out. I mean, I would agree that it's not my strongest argument. I mean, but I think it is.
I think he said. I mean, the prosecutor didn't say unequivocally that's what the witness said. She prefaced the remarks with, I think he said. And then we give an instruction on closings and openings, right?
Correct. Yes, Your Honor.
Was the whole hour-long video played for the jury from that? Because we have an hour-long video that we saw.
No, I believe the parties agreed to what parts can come in.
Okay, did the part that come in that showed the cool police stuff? You know, because there's a computer, I mean, that whole way the driver's side of the police car is set up. I mean, my car does not have a nice computer like that in it.
I know there were pictures. So the way the evidence came in, there's the defendant took like a screenshot of the video which showed the defendant's identification on the computer screen.
Right.
And I know that came to evidence. I really do not recall if the jury saw that.
Okay.
I know I'm running around time. If there are any questions, I'd like to briefly discuss my last argument. The last argument, Your Honor, discusses whether or not there's a proper colloquy at the end. Knowing that first, and I'm aware that the defendant had his attorney withdrew, and then that's obvious. What I'm stating here, when you read the transcript, it's very, I think the Commonwealth used a pretty good word, truncated, and it's not really clear what plea and what rights are being discussed where. And the reason why this is important is it's very confusing, and for some reason in that courthouse they used a different attorney waiver than the one that the SJC has been using for a long time. And it's very difficult to determine what rights are given where. And why this is
where a defendant is waiving counsel after a jury trial but before sentencing, what rights should the judge tell the defendant about before accepting the waiver?
I think almost the same rights as if you're going to waive and do your trial, go pro se. Obviously, you don't. The rights of jury and all of that have now passed because that's gone. I still think he has to do voluntarily. It has to be knowingly that he's not under the influence and he's making the and he believes is the right choice. I think as a trial attorney, I think I know what I would say. That's try to talk him out of it. But once again, we're here with now, and there has to be a reason why the SJC says the judges shall follow this procedure. I know there is case law that says, you don't have to have exact words. But
I think the question was, what do you think at that point, after trial has concluded, the judge needed to say as a matter of constitutional law? What did the judge not say that the judge needed to say?
Okay. I don't believe he stated knowingly, voluntarily. Knowingly, I had this in my head, knowingly, involuntarily, intelligently, and
Right, but
it's very
so
unclear.
you're saying, see, those seem to me to be what the judge needs to establish or find or be comfortable with. You think the judge needs to say, sir, I need to determine that your waiver is knowing and voluntary?
Yes, Your Honor. For example, like in the district court, the green sheets, once they go over, if somebody changes their plea, they're going to ask them something along the lines of, are you doing this knowingly, voluntarily, no one's coerced you, no one's promised you anything in
Did
return
ask
for
the
this?
coercion question, I think.
Yes.
So factually, though, what it looks like is you have the waiver in this case, but then before the judge sentences in this case, the judge does a more full colloquy in the other case, correct?
Yes, so, yes. And the way it first starts is the trial attorney withdraws, and immediately the judge says, the sentence is going to be such and such. They go through that, and then they start talking about the change of plea in the other case, and then the sentencing. And I understand he probably didn't do himself very many favors during his sentencing argument, but,
Well, he seemed to know what he wanted.
oh, right, but
At the end of the day, he got what he wanted, no probation.
I guess that's a different opinion. I wouldn't want more jail time, but
Do you agree that the attorney had already filed a sentencing memorandum on behalf of the defendant before the withdrawal?
yes. If there aren't any other questions, I would rest on my.
Thank you. We'll hear from the Commonwealth.
Thank you. Thank you for your time. Good luck.
Good morning. May it please the court, Kristen Jang for the Commonwealth. So I can just go in the order of my brother's brief, if that pleases the court. As to the first issue on the closing argument, as was indicated during my brother's argument, I didn't read the section that's at issue here of the prosecutor's closing argument as her defining or trying to define the concept of reasonable doubt. She was simply arguing, she also did not argue that the jury was required to find a certain percentage probability that the defendant was the perpetrator of the crime, which there's lots of cases about how that's improper. What she was doing was summarizing the Commonwealth's evidence.
Summarizing it with percentages.
She was.
She said, you have 50% here, we'll start with that baseline, and here's the other 50%. Do you agree that it's better practice to stay away from that when discussing reasonable doubt?
I don't know that she wasn't discussing it in terms of the jury needs to find this percentage to find beyond a reasonable doubt.
You have that percentage. She didn't say you need to find it, she's saying you have it.
She did say you have it. Was it the most clear way to summarize the evidence? Maybe not, but it was at the end of a long day of trial, and the defendant's not entitled to a perfect trial. He's entitled to a fair trial. I don't think this went over the line to so confuse the jury about what the Commonwealth's burden was here. Also, I would like to point out that the standard here is substantial risk. So there were extensive instructions from the judge that the judge was going to inform the jury about the standard of proof here. The judge provided a complete and correct instruction in reasonable doubt, and the judge told the jury to apply the law as instructed. There was also overwhelming evidence here.
You said the defendant's not entitled to a perfect trial.
Correct.
But a fair trial. So does
Yes.
that suggest that it would have been more perfect had she stayed away from that argument?
It wasn't the clearest way to summarize the evidence. I will admit that. It wasn't the clearest way, but I think she was trying to use just the fact that the victim said he was 50% certain, so she was just kind of using that number. I don't think it strayed into an area where she was confusing the jury as to the Commonwealth's burden. She was just using that number because it was a convenient number to use. As to the second claim of error in the closing argument, that the prosecutor vouched for the victim's credibility in some way, I don't think there was any vouching in this case. I think she was just summarizing the evidence in the Commonwealth's favor. Same with the argument about trying to garner sympathy for the victim. The Commonwealth had the burden of showing that the defendant had put the victim in fear. So that was relevant evidence. It was part of our burden to prove. And as to the last argument about misstating the evidence, To the extent that there was a misstatement about cool police stuff.
There was no evidence of cool police stuff, right? Just, except perhaps something visual.
Correct, correct. So not quite sure where that came from, but I don't think it was really material to any contested issue in this case because we had testimony from the victim saying he didn't see any photographs of anyone when he was sitting in the officer's cruiser. So I don't really think it made any difference to the trial. And as to the last issue in this case, the sentencing issue, so I do agree with my brother that, I would have liked to have seen a more full colloquy at the very beginning of the hearing. So the sort of colloquy that she eventually went through with the defendant when he waived counsel as to his other case, confirming that he wasn't.
We consider that second colloquy?
What's that?
Can we consider that second colloquy?
Yes, yes, you can. I would have liked.
Why? I mean, hadn't the judge already, it's hard to tell. The judge had already indicated what her sentence was.
Right.
In the first case.
Correct. So I would have liked to see.
He was unrepresented. And as to
Yes.
which, was there even a colloquy?
There was. So she asked to confirm.
So you want to represent yourself? Answer, yes.
She confirmed that you understand that I'm going to move forward with sentencing today. Yes. Do you want to talk to an attorney about representing yourself? The defendant said no. So that all happened before any argument occurred on sentencing.
Is that satisfactory as a colloquy to determine a knowing and intelligent waiver?
I think with the understanding that the sentencing memo was filed as well, that happened too, so the defendant knew he wasn't going to have to make any of the substantive arguments in that memorandum. I think that was sufficient, and then you add all the rest that she eventually garnered through this other proceeding. And when you take all of that together, under Pamplona, you can look at the circumstances of the case as a whole. So I do believe that was sufficient.
Does this defendant have any experience with the criminal justice system?
There was reference to his criminal history vaguely during the hearing. It didn't come out exactly what that was, but there was reference to it. He obviously had another case pending as well. And he had been through
Prior
an
to
entire
this.
trial.
Prior to this, did he have any prior convictions?
There was a reference to a prior conviction, that a sentence on a prior conviction had completed. We don't quite know what that was, though. That is not part of the record.
Do you agree that he signed an outdated waiver form?
Yes, I do. I do agree that that wasn't the correct form, but there is case law stating that that's not enough to find that the waiver was invalid. You still have to look at the rest of the circumstances of the case. And I also want to point to the fact that even if this court finds that there wasn't a knowing and voluntary waiver here, the defendant would just get a new sentencing hearing. He's not going to get a new trial. He had an attorney throughout the entire trial. So that would be the remedy.
At the end of the day, did the judge change her previously announced disposition to one that was actually what the defendant requested?
She did, yes.
Has he finished the sentence?
He has not. I believe he's still serving a sentence on the first count.
Does it matter? Is there some sort of prejudice prong to an analysis of whether the colloquy was adequate?
There is no prejudice prong, because I believe I've cited some cases in my brief that the right to counsel is so fundamental that you don't even get to the prejudice
I
analysis.
assume all those cases are going to be in the context of right to counsel at trial, not to a
Correct.
right to counsel at sentencing, right?
There is a case that it's a critical stage, so right to counsel also attaches to sentencing as well. I believe it's Pacheco.
I'm struggling with what more the judge was supposed to say if the colloquy is determined to be. Okay, so she's having a colloquy. He says, I want to represent myself. She has to determine that that's knowing and voluntary, right?
Yes. So I would have liked at the beginning of the sentencing hearing for her to have asked at that point whether he understood that he would be held to the same standard as an attorney if he represented himself. So that eventually happened during the second case. And I would have liked for her to ask whether he had taken any medication that could affect his ability to represent himself that day, whether he was under the influence of anything. questions like that. I would have liked to have heard a little bit earlier before any argument was taken, but she did eventually ask those questions, and before she entered the final sentence, she was aware of that.
Well, she'd been observing the defendant throughout the trial that day, correct?
Yes, the trial wasn't that same day, but it was previously, and it was the same judge that had observed the defendant during the trial. That's correct.
It was the trial had been almost a month earlier. Right?
Correct.
A sense of the magnitude of the undertaking and the disadvantages of self-representation. Does it matter that, as Judge Desmond points out, that the actual sentence was not imposed until after those kinds of questions had been asked?
It does matter because it did give the judge the opportunity to maybe find out, wait a minute, maybe there wasn't an adequate waiver here. Maybe it wasn't knowing and voluntary. If his answers to those questions were different, she still had the opportunity to pause the proceedings and maybe get counsel for the defendant. And if there are no
the usual practice would be, so he says, I want to represent myself. The usual practice would be that he needs to sign a written waiver form.
Yes.
And also a green sheet, right?
Yes.
Or is the green sheet just for the plea?
Or actually, I think the green sheet might just be for the plea, but a waiver of counsel form would have been appropriate here with the certification from the judge.
Okay.
And if there are no further questions, I'm happy to rest on my brief.
Thank you very
Thank
much,
you very
counsel.
much.
Your case is submitted. The next case on our list is 2022-P-982, Commonwealth versus Keogh.
Good morning, Your Honors. May it please the Court, Patrick Levin on behalf of NICKY Keogh. This case presents a Second Amendment challenge to the 1974 Bartley-Fox Amendment, which imposed a mandatory minimum sentence for a violation of the Commonwealth's regulatory scheme for the licensure of firearms. Prior to the amendment, the statute here at issue, Chapter 269, Section 10, provided that if a person was found carrying a pistol without such a license, they would be subject to a sentence of not more than 5 years in state prison, not less than, I believe it was 6 months in the county jail, but there was an available disposition of probation or the sentence could be suspended. And for a person who had not previously been convicted of a felony, the available dispositions were up to 6 months in the House of Correction or a $50 fine. That was consistent with our nation's historical tradition of firearms regulations in the sense that it was consistent with the penalties for regulatory public welfare type offenses, which is what we have here. This is a statute that punishes simply the possession of a firearm without prior compliance with the regulatory scheme.
So I'm going to pause you here. I have a housekeeping matter, which is what order or orders are you appealing from? Is it you're appealing from the sentence and the motion to withdraw the plea or to correct the sentence, or both?
That's correct. So there's a notice of appeal from the judgment, and then there's a separate notice of appeal from the judge's denial of the motion either to correct the sentence or to withdraw the plea.
So it was like a Rule 29?
It was filed under Rule 30 as a motion
38.
to correct an illegal sentence. Yeah.
And that was filed within 30 days, I think, of the sentence itself, right?
The notice of appeal was filed within 30 days of the plea colloquy, and then the Rule 30 motion was filed within a week after the notice of appeal, I believe.
So the Commonwealth argues that Chapter 269, Section 10A is, well, really that Bruin has no effect here because what we're talking about is a punishment, not the regulation itself. So what do you say to that?
So essentially what I say is that the punishment is part of this regulatory scheme, and that the imposition of the mandatory minimum sentence, as opposed to the prior availability of a punishment as light as a $50 fine for someone with no prior felony convictions, on a crime that requires no inherently wrongful conduct and no awareness of any wrongdoing, renders the entire regulatory scheme so qualitatively more severe as to represent a clear break from our nation's historical tradition of firearms regulations. And everyone at the time that the amendment was passed was aware that this was a clear break. You can see this from the Jackson opinion, which talks about this is the first statute anywhere in the nation to impose a mandatory minimum sentence on a first offender for merely carrying a firearm, and that the reason that the penalty was upheld was the necessity to allow the legislature to experiment with gun control in an attempt to meet the challenges posed by firearm violence in our nation's urban communities. But what Bruin says is that problem of firearm violence in our nation's urban communities is one that has been faced by our society since the founding. And therefore, in order for an attempt to address that problem, to pass muster under the Second Amendment, it must be distinctly similar to our nation's historical attempts.
So, just to be clear, though, you're not attacking the regulatory scheme, is that
No,
correct?
not whatsoever. The only portion of the statutory scheme that we're challenging is the 18-month mandatory minimum sentence and the disallowance of probation or suspension or, reduction of time for good conduct.
But I guess what I find a little puzzling is in Bruin, the sin of the New York statute, that is what the reason they struck it down was because the other 43 states had objective criteria and New York had subjective criteria, and yet what you're arguing is for a subjective discretionary sentence. And what they didn't like was the discretionary part of the New York statute, and that's what you're now asking for here. So how does that work?
Well, Your Honor, there's a difference between the ex ante exercise of discretion to decide whether someone is entitled to exercise their constitutional rights at all, and the ex post evaluation, the inherently judicial function of sentencing, which can take into account whatever mitigating factors may exist, such as the fact that someone may have no prior felony convictions, may not even have been aware of the requirement of licensure. If you look at the Staples decision, which I cite in my brief, what the Supreme Court says, and as far back as 1992 or 3, I believe that case was, is that the mere possession of an ordinary gun is not the kind of conduct that we regard as so inherently wrongful that people are naturally on notice.
But it's not the mere possession. I mean, the crime is possessing it without getting a license.
Well, but that's what I'm saying, is that the mere possession of a gun is not an act that is inherently wrongful in a way that naturally puts the public on notice that this type of pre-clearance is required, especially in light of the fact that that conduct is protected by the plain text of one of the fundamental provisions of our Bill of Rights.
Now I think you're straying into what I thought we wrote out at the top with Judge Desmond's question. It sounds to me like you're complaining about the licensing scheme. It's clear that the licensing scheme is constitutional, right?
I agree. The licensing scheme is constitutional, but the question is whether our licensing scheme taken as a whole in light of the penalty imposed imposes a substantially greater burden on the right to bear arms, such that...
I'm sorry to interrupt you, but that seems to find fault with the licensing scheme.
Yes, it finds fault with the penalty portion of the scheme. And so to the extent that had the Bartley-Fox Amendment not been passed, then we would have no quarrel with this.
In other words, you're saying it's fine to require a license, it's just that the penalty is so great and mandatory that that's the constitutional problem.
That's right, and you can see both in Bruin and in Heller, when the court is analyzing historical regulations to determine whether they're sufficiently analogous to the regulations there under review, that the new regulations are consistent with the Second Amendment, the court looks at the penalties that are attached to those regulations.
I read both this morning for that issue, and I didn't see those cases being concerned about sentencing. I didn't see it.
So, Your Honor, I'm on pages 633 and 34 of the Heller decision. A broader point about the laws that Justice Breyer cites, all of them punish the discharge or loading of guns with a small fine and forfeiture of a weapon, or in a few cases, a very brief stay in the local jail. Not with significant criminal penalties. They're akin to modern penalties for minor public safety infractions like speeding or jaywalking. And this is one of the reasons that the court cites that for why those historical statutes are not sufficiently analogous to the modern statutes as to render the modern statutes of a piece with the nation's historical tradition.
Because there in Heller, they're talking about limitations on possession. I think of maybe handguns in the one that you're reading there.
So
you're sort of saying, well, yeah, it's true that there were some statutes that limit the possession of handguns, but the penalties were so slim, we're not seeing those.
You couldn't keep loaded firearms in the home under those old Massachusetts statutes that he was talking about, yes. Which Justice Breyer said, well, that's basically the same as what Washington, D.C. does. And Justice Scalia says, well, first, no, it's not really. But second, the point of those statutes, A, was for the safety of firefighters in the event of a fire. But B, these are essentially public welfare offenses that, they have small penalties. They don't shed light. They don't render this modern harsh penalty part of the nation's historical tradition. And I want to emphasize, as I do in my reply brief, that although most constitutional litigation does deal with the substantive content of the regulations at issue, it is not unheard of by any means for the Supreme Court to look to penalties to inform the analysis. In the First Amendment...
Well, before you go into that, I want to back up. I have a couple of questions. So first you say, well, maybe, this particular regulatory scheme doesn't even, he may not even know it exists that he needs to get a license. But wasn't he doing more than just having a gun here? Didn't he have cocaine with him?
So a couple things about that. First, this is a facial challenge. So what I'm saying is that the conduct that the legislature has criminalized in conjunction with the penalty for that conduct is not consistent with our nation's history of firearms regulation. But second, he was only convicted of possessing the firearm. That's all he's been convicted of.
So you're saying
that
nobody can consider that he had cocaine with him?
I'm sorry?
We can't consider that he had cocaine with him?
Your Honor, he is presumptively innocent of that. For legal purposes, he did not have any cocaine. And he's never been convicted of any other crime, ever in his life.
What do you say? I heard you use the words distinctly similar earlier, that you think the standard is that in order for a regulation, let's assume that this is a gun regulation, that the punitive component of the statute is part of the gun regulation, which the Commonwealth challenges, but that it has to be, quote, distinctly similar to the nation's historical. And where do you draw that from?
Well, that's the language of Bruin, Your Honor. That is at page 2131. When a challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenge...
Relevant evidence, but
yes.
You're saying that's the standard. And then I have this difficulty with Bruin, which is that there are 6 people in Bruin, but then there are 2 who concur. And the concurrence... So that means you only have 4 votes for that language if the concurrence detracts from it. And the concurrence goes on a long list of things that are lawful under the Second Amendment.
Yes, Your Honor.
So how do we read those together?
Well, I want to emphasize that the concurrence begins by emphasizing that he joins the majority opinion in full.
Well, yeah, but he also says this is what the majority
Exactly.
opinion holds, 1-2, and then he's done. And he does not hold, he's not going as broadly as you are reading the decision. And you may be right about where the Supreme Court will ultimately go, but 2 of the 6 judges in the majority were definitely not there now. So what do we do with that?
Well, Your Honor, I think that, all I can do and all this court can do is its best to apply the test, the analytical test that the Supreme Court has laid down. And that test did.
But this is the rub of the whole case, is do we apply the holding that all 6 judges clearly agree on, which is not as broad as you are arguing, or do we apply this because they could have made it a plurality, but they didn't? And nobody's briefed that issue.
Well, I don't think there's anything there to brief. 6 justices joined.
Well, there are law review articles on this topic.
But
There's plenty to brief.
I mean, it's pretty important, okay? Because you want to use the terms distinctly similar. You just read it to me, and it says, is relevant to.
Well,
and then I have to take that language, and I have to lay it next to what 2 of the judges said, which is all these things are lawful. Let's be clear, all these things are lawful. And some of those things may not have been distinctly similar to what was regulated in the 18th century.
Well, but so there's 2 parts to the so it's if it's a general societal problem that has persisted since the 18th century, then you need to have a distinctly similar historical regulation that addresses that problem, or that prior generations did not address that problem through a material different means. If it addresses a novel problem that the founders could not have foreseen, then we do this analogical test where we try to analogize to the historical regulations. And, there's several.
Could one make the argument that that's what this act that you're challenging was doing, was addressing something that perhaps was not foreseeable? Because the population changes are so radical between the 1800s and 1970. Having to keep track of who was walking around with a gun was a lot harder.
Yes, certainly one could make that argument. The Commonwealth hasn't in this case. But, I certainly think that position is not really consistent with Heller. Because that's essentially, the idea that this is the same societal problem that has persisted since the 18th century is this problem of handgun violence in densely populated communities. That's what Heller and Bruin say, and that seems to be the same problem at issue here.
Let me ask you this question just for a moment, and I'll let you return to your answer if it's not complete. Have you finished your answer? Let me start.
Yes, Your Honor, please.
The mandatory minimums, do we know why, what those were in response to?
Well, there was this perceived, Jackson talks about this at some length, the legislative history, and there was a perception of and I think an ongoing problem of handgun violence in our nation's urban communities. Was
there also a perception of disparate dispositions with respect to offenders?
I'm not aware of any discussion of that in the legislative history. I certainly, there was a lot of legislative and scholarly debate about the efficacy of mandatory minimum sentencing at that time. And one of the driving forces was the shift from a focus on punishment and rehabilitation to a focus on deterrence. And I think that was, the primary intellectual motivation behind the shift to mandatory sentencing, is that we want the certainty of punishment as the deterrent value of that. And you can see that from the article that I cite in the opening brief. The BU Law Review article talks about the public relations campaign that surrounded the passage of this bill, and the television advertisements and
We have that, and I have a couple more questions, and
Yes,
I'm
please, Your
mindful you're over time. We'll handle that with the Commonwealth as well. Briefly, has any federal or state court adopted the interpretation of Bruin that you were urging here?
I'm not aware of any prior challenge to a penalty aspect of a regulatory scheme.
And do you have a view as to whether Guadardo, the SJC's recent decision, has any impact on this case at all?
No, in my view, there's not really any relationship between the two arguments.
All right. Your brief seems to suggest that punishment for violating the license, for not having a license is permissible, and you seem to suggest that it could be sureties or until sureties are posted. And in one of the statutes, it seemed like that someone could be held for until they posted 5 pounds. So does someone have to do some research as to how long it would take somebody in either 1868 or 1791 to post 5 pounds?
Well, the time to have done that research would have been before we were here this morning, Your Honor. The Bruin decision makes clear that...
Are we supposed to be doing that research, or is the Commonwealth supposed to be doing that research?
The
Or you?
Bruin decision makes clear that the burden is on the Commonwealth to bring the challenged regulation within the nation's historical tradition, and at footnote 6, directs courts to decide these historical disputes on the historical record compiled by the parties.
Thank you. Any other questions? Thank you.
Thank you very much, Your Honors.
We'll hear from the Commonwealth.
Thank you, Your Honors. May it please the Court, Assistant District Attorney Ryan Rawl from Middlesex County, representing the Commonwealth. The sole issue in this case is whether the defendant's right to bear or keep arms is infringed after he is convicted properly of unlawful carrying of a firearm without a license and then punished to a sentence of incarceration that is mandatory as compared to discretionary. The answer to that question is a very straightforward no. And I want to start by just putting out the plain language of the opinion of Bruin, because I believe that the defendant not only overstretches the imagination of what Bruin stands for, but the plain language contradicts him about what Bruin says. So, footnote 9 from the opinion. To be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. Because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding, responsible citizens from exercising their Second Amendment rights.
All right, so let's back up for a minute. First of all, the defendant is making an argument that, but for the mandatory minimum sentence, this particular defendant, who had no prior charges and no issues during the pendency of this case, would be getting a sentence of probation. Do you agree with that?
Well, I agree that if there was no mandatory minimum, the judge could give a different sentence
Well, I'm
than 18
looking at
months.
this particular transcript. Does it seem like the judge would have been heading towards probation?
I would acknowledge that the judge makes comments that he would have been willing to give probation if he were allowed to.
And do you agree with your colleague that we don't consider the cocaine at all because there's no conviction?
I would say insofar as you consider the facts of the case, we are getting into what the defendant's brief is really about, which is a thinly veiled Eighth Amendment proportionality argument about his particular defendant throughout his brief. But no, because as a part of the plea, we agreed to dismiss the possession with intent Class B, the fact that the firearm actually had a defaced serial number, as well as previously we had decided not to indict the case. He was originally charged with possession of a firearm while in the commission of a felony. And so those charges were all dropped. But it does speak to the fact that the defendant's attempted argument of, I was just peaceably carrying a firearm, I mean, that the record doesn't support that, but that's neither here nor there. The fundamental problem with the defendant's brief is that Bruin doesn't stand for what he says Bruin stands for. And you go on to the concurrences with Alito.
Well, he makes a pretty compelling argument that you've got to consider the punishment. I mean, I'll use a different example, but, if the punishment for letting someone's dog off leash is $50, there are going to be some off-leash dogs. If the punishment is $10,000, those dogs are going to be leashed.
And in that scenario, that would be an Eighth Amendment proportionality, cruel, and unusual punishment under the Constitution. That's exactly what the Eighth Amendment is about proportionality.
What about all the First Amendment cases that he's citing in his reply brief that go through some sort of indication of the penalty for the violation?
So I'm glad you asked that, because they They don't actually do that in the way that he describes, and there's a couple problems. First of all, those cases have to do with analyzing the tiers and level of scrutiny they will apply, which isn't even available now as a result of the Bruin analysis. So
I don't understand. Help me with what your argument is, though, because are you saying that the Second Amendment doesn't apply because the Eighth Amendment has occupied the field?
I will start by saying that in this particular case, where the defendant is acknowledging that his right to bear arms was not infringed, because he is acknowledging not only that the licensing schemes that he had to follow were constitutional, he then acknowledged in a plea that his behavior was not constitutionally protected because he agreed that he unlawfully carried that firearm.
I don't know that, counsel, I don't hear him saying my right to bear arms was not infringed. I hear him saying the opposite. I hear him saying that the Second Amendment is violated by the entire regulatory scheme, which includes the punishment. And I'm trying to understand why. I mean, there are a couple ways you can go at this, but the one which it seems to me you're arguing now is that the punishment is separate. It's not a regulation of firearms. We should ignore it. That's an Eighth Amendment problem. Is that?
That's one of the arguments I would make, is that in particular, you can't even get past the fundamental first step of Bruin, which is, does the penalty portion on its own, which is the only thing he's challenging, does that infringe upon a law-abiding citizen right to keep and bear arms? It doesn't. You can't get past the fact that if you accept that the licensing restrictions are constitutional, and you accept that this defendant engaged in unprotected conduct.
I'm looking at a statute, and it says, number one, you need to have a license before you can carry, Section A, you need to have a license before you can carry a firearm. I don't know if it's in Section A. And then someplace, I think in that same statute, it says, and if you violate this, 18 months mandatory minimum. And you want us to separate them and say, that's a regulation of the firearm, and that's not.
Well, I don't want you to separate it per se.
To read the statute or to think about the issue?
I think that's the correct way to look at Bruin, because what Bruin is saying is that, is the conduct protected? Is the conduct being infringed? So is my right to carry a firearm?
But that's because that was the question in Bruin. There wasn't a question about punishment in Bruin. It was
Right.
simply a question of whether they could regulate the carrying publicly.
Right, and in all the cases, whether you're talking about Heller, McDonald, or Bruin, the question is always, and I disagree with my brother's characterizations that they considered the penalty in Heller or in Bruin. What they are talking about is, here is what was an acceptable burden on people's right to self-defense at the time. Here was an acceptable burden on the possession of a firearm. And this is not that. You cannot effectively ban someone from carrying a firearm outside for self-defense, which is what the New York statute was doing, and you can't effectively ban someone from having a firearm in their own home for self-defense, which is what Heller and McDonald are talking about.
Right, but the problem for you is that Bruin has some very broad language in it that does seem to implicate the punishment. If you look at the decision, it says that only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the conduct falls outside the Second Amendment's unqualified command. And if the punishments now are vastly different from the punishments in either the late 1700s or middle of the 1800s, then what's the defense to that?
Well, I'll make a couple of responses to that. First is that when we're talking about Bruin's decision, while it's written broadly, the question is about whether the regulation infringes on the right to bear arms. Once you get to a point where it's a reasonable restriction, and the court said in no uncertain terms between the concurring opinions of Alito and Kavanaugh in the majority that you can still criminalize, you can still punish. One of the statutes that's maintained and upheld, as I put in my brief, is the Connecticut statute, which has a 1-year mandatory minimum and a 5-year max state prison sentence. That Bruin didn't affect that at all, according to its own language. So that's the first piece. But the second piece is, as I mentioned, even though I don't think we need to address the novelty of it, What the defendant isn't arguing is that 5 years in state prison at a discretionary level violates my right to bear arms. He's specifically targeting the mandatory minimum provision. There's a couple problems with that. The first is, how does that specific provision affect the right to bear arms, and being sentenced to 5 years in state prison on a discretionary not? So that's one of the problems. The second problem is, it actually isn't novel to incarcerate people. There's a longstanding historical tradition of incarceration. As I point out in my brief, by the 1800s, incarceration has encompassed the norm, so to speak, as compared to corporal punishment. And I do want to point out that this concept of mandatory minimums, it's described as novel because by this point in our nation's history and in Massachusetts, we have probation by the 1870s. We have parole shortly thereafter. We have these good time credits for sentences that we start imposing. There is a shift in the overall American society towards rehabilitation around the time where probation is codified.
I want you to finish that answer, but I have a question to follow up. Go ahead.
Oh, sorry. And so my point is that when you got a sentence back then before probation and parole, it was a mandatory sentence. There was no parole. There was no good time credits that were codified in Massachusetts around that time period. So my point is that to say that a mandatory minimum term of incarceration is novel, back then a term of incarceration was a term of incarceration. That's
All right, so let's just make this simple. Let's assume in the appropriate time period, which the concurrences in Bruin point out we don't know yet, but whether it's the late 1700s or the passage of the 14th Amendment, but let's assume that the most punishment in any state at that point was 30 days, okay, of incarceration. So you think that is not in any kind of boundary on what you can have for incarceration today under Bruin?
I think, first of all, I would say I believe that the 14th Amendment passage is the appropriate time for him to look at, so by the 1860s. On that question of where to look, I know that's an open question. But the second point is that I don't think that Bruin needs to be construed that narrowly. I cited in my brief a case called Ex parte Isidore, which talks about the general historical understandings about allowing restrictions on pretrial release. And their argument is not specific to firearms, that you were allowed to do it specific to firearms. They point that there's a longstanding historical tradition in general of being allowed to impose restrictions that affect people's constitutional rights pretrial. I would make the same argument here, even though the defendant does point out that there are statutes that allowed a decent term of incarceration for firearm offenses at the time going back before the 1860s. But even so, my point would be that the longstanding historical tradition of states having the discretion to incarcerate people set those terms of punishment and incarcerate people for a variety of public welfare and regulatory offenses at the time in which the 14th Amendment is passed. There can be no reasonable argument made that because at that time they chose not to do firearms in that particular state or in certain particular states to be
Did
opposed
any
to
of them do firearms? I mean, I know the answer to that is yes. But most of the yeses, for example, you can't bring it before the court. Or you can't have a firearm if we think that you're using it offensively or you're using it to terrorize. Were there any licensing schemes in effect prior to 1868?
No, which is why you need to look to the Bruin decision, the Heller decision, and the McDonald decision.
I'm sorry.
Go ahead.
So what gun regulation that existed prior to the 14th Amendment's enactment is out there that we can think of as being the basis for the concurrence's view that licensing schemes are fine, that regulations on where you take guns, if they're in particular places, are fine? What are the actual gun regulation that existed prior to 1868?
Well,
not licensing, so what else?
Well, first I'll say I think that's a hypothetical academic exercise in this case because the defendant here is agreeing that those licensing schemes were reasonable and constitutional. So you don't have to ask that question about licensing schemes in general because the defendant's acknowledging his behavior is criminal and he doesn't want to vacate his plea.
That isn't the...
But to get to...
It's not helpful for you to try to figure out why I asked the question, okay? I need you to help me by answering it.
Right. So the answer to that question is going to Scalia and Breyer in Heller, going through the decisions Heller, McDonald, and Bruin, which just reaffirms both in the majority and the concurrences, there is a historical tradition, and they acknowledge and they say throughout all of those opinions, we are not saying that you cannot restrict people who are mentally ill, who are felons, who are violent offenders from having firearms through a licensing scheme.
I'm trying to understand what existed, because we have this case that says we have to look at historical traditions.
So do we know if there was an offense, possession of a firearm in the commission of a felony back then?
So I have to be very blunt in saying that because the defendant himself did not raise any of these issues about the licensing scheme except for the penalty portion, I haven't done sort of full research on that issue. It's never been raised. I'm aware.
What do Heller and, I mean, I read Bruin, you know, I see that there was something in 1300 in England about, you know, not having weapons used to terrorize, or you can't take them to fairs. I saw that, but I'm trying to understand what existed in the United States, and the answer is we don't really have something in the case law that tells us?
Well, I think that the historical analysis in Heller, McDonald, and Bruin walk through the various types of statutes that existed. There were prohibitions on specific types of weapons. There were prohibitions on certain people having types of firearms over the years. If it was an issue in this case, I obviously would have spent a substantial amount of time researching that particular question. But here, where the defendant is basically disavowing any claim that the licensing scheme requirements on him to have a license, to follow the criteria in Massachusetts, is constitutional. He's saying it is constitutional. The only question is the penalty. That was what sort of the focus was for me on researching.
Let me just ask a slightly different question. Let's assume for the sake of discussion we agree that the disposition was illegal. Right? Let's say that 18 months mandatory is not constitutional. So then what? What do? He says we just send it back for sentencing, is that right? Or does that negate the whole negotiated plea? Do you get to bring back the possession of B with intent and the commission of a felony? Do you get to?
It negates the entire negotiated plea, because what would have to be done in what the Commonwealth agreed to in an agreed upon plea, which was agreed by the defendant, was 18 months in the House of Correction and dismissal of all these charges as a part of the plea. So that's where we would be.
All right, so he says that focusing on the punishment here, you have not identified any historical analog that would, let's assume, for example, that we disagree with you and that we think Bruin will cover punishment. And so he says, well, you haven't provided us with any historical analog that would support the 18-month minimum mandatory sentence for this sort of offender. So do you agree with him you have not provided that historical analog, that that's just not your approach to the case?
What I would say is I do address in my brief that this is not novel, that the concept of being incarcerated generally has a long-standing.
Look, I agree with that. He seems to agree the concept of being incarcerated is not novel, but the question is the length of the incarceration.
He seems to agree that if the judge decided 5 years in state prison was an acceptable sentence for it, then that would be fine.
I think
but-
he's
18 months to the house, right? This isn't even a state prison sentence.
Correct. But in his argument, what he said is the issue is whether it's discretionary or mandatory, not being sentenced to
But
incarceration
see,
generally.
the question that Judge Henry just asked you is really what I was getting at with the questions that I asked you before. What is the historical evidence of the penalties that were given with respect to gun violations prior to the 1870s?
I think that the short answer to that, it is difficult to find a gun law regulatory specific provision, because gun licensing in general, as a general principle, did not exist until post 14th Amendment.
And that's
So-
why you keep talking to us about incarceration generally, because the questions don't fit from your perspective, because you're talking about gun licensing, which didn't really exist then either.
Correct. That's part of the problem.
At that time, was there a distinction between a state prison sentence and a House of Correction sentence?
I want to say that there was, because there was a distinction in the variety of crimes and what one could be sentenced by this time period, in particular in the 1800s. So I do believe by that point there were both felonies and misdemeanors, and that there was a range of offenses available, including house time and state prison. But I don't want to say that definitively just because I haven't researched and confirmed that exact answer.
All right, so I want to talk about Guardado for a moment because the SJC seems to have signaled to us that it sees Bruin as a sea change, right? Because Guardado says now the Commonwealth has to bear the burden of proof that the defendant is not licensed, and that's not expressly stated in Bruin, right?
Right. I would say it's not expressly stated in Bruin per se, but I would say that Guardado is a very logical conclusion based on existing precedent, which is when you accept that carrying a firearm is constitutionally protected activity or possibly constitutionally protected, it's the Commonwealth's burden to show that it was not constitutionally protected at a trial, kind of like a presumed protected class of speech in the First Amendment. So I actually don't see it as a sea change. I see it as a logical conclusion that if we accept that carrying a firearm...
I think Guardado was a sea change, but was Bruin a sea change?
So I disagree that Guardado or Bruin were a sea change. I think that
Really?
Guardado...
Bruin you don't see as a sea change?
I'm sorry?
Bruin you don't see as a sea change?
I think Bruin changed the rule, but what Bruin said was that their opinion was very narrow. I think the changing of the rule requires a complete reworking, and in that sense it would be a sea change. The legal standard is a sea change. But the impact, given the concurrence's opinions and the footnote in the majorities, is not. I mean, if these licensing schemes in the 43 other states can continue to incarcerate people for example, 1 year mandatory minimum, 5 years in state prison, I don't see the sea change that the defendant is
We
arguing.
haven't, the other states haven't reached that question.
Yeah, there's no case that says 1 year mandatory. That's certainly not what Bruin says in the footnote, that a 1 year mandatory minimum is okay. I assume if that happened, we probably wouldn't be here.
And it wouldn't say that because it doesn't, once you accept that your conduct is not protected under the Second Amendment because you've been properly convicted and the sentence really doesn't infringe on the right to bear arms. But the final point I'll say is, because I know the court asked this before, is I reviewed all the recent federal and state appellate decisions, and there's been no discussion of the penalty portion in particular having any impact on the Second Amendment right.
All right, so I want to make sure we ask you a question that we asked your learned colleague, which is, what is the role of an intermediate appeals court, just hypothetically say, like this court, when you have a Supreme Court decision that has 6 judges who sign it, they did not make it a plurality, but then 2 of those judges, which would then take away the majority, 2 of them say, but this is what we're holding and we're not holding more than that. So what do we do with that?
Well, what I would say is the general principles of appellate courts is that you do not overrule a decision such as Jackson, which upheld the constitutionality of this sentencing scheme of the statute, by dicta that we attempt to interpret from a plurality of the Supreme Court in which our own Supreme Court has not provided any guidance. So I think the answer for the intermediate appellate court in this case, unfortunately, is that it needs to affirm the legality of the sentence absent the Supreme Judicial Court of the Supreme Court giving an explicit burden.
Dicta. It's a holding signed by 6 people that 2 then went and said, well, just to be clear, we're taking that away.
I would say that it would be dicta to say that they are in any way attacking the constitutionality of a sentencing provision of a licensing scheme.
Excellent argument from both of you. Very interesting case. It's under submission. Thank you very much. Our third case for today is 2022-P-632, and I'm actually going to have the defense attorney tell us how to pronounce his client's last name so I don't butcher it, and we're all on the right page from the start.
My client's name is Stephen WAYLEIN.
I'm glad I had you pronounce it. When you're ready.
Good morning, Your Honors. May it please the Court, my name is Edward Gauthier, and I'm appearing today to argue on behalf of the defendant appellant, Stephen WAYLEIN. An Essex Superior Court jury found Mr. WAYLEIN to be a sexually dangerous person. There were 2 experts for the Commonwealth and 3 experts for the defense. The issue was whether he is a pedophile and whether he is currently a sexually dangerous person. Both experts for the Commonwealth said yes. All 3 experts for the defense said no. The first issue is whether
Could
the...
I just ask a house,
It was a jury trial, yes.
housekeeping matter? Your brief had a Moffitt certification.
Yes, Your Honor.
Could you elaborate? You're advancing all of the arguments in the brief, right?
I'm arguing today on behalf of Mr. WAYLEIN because he's incarcerated at the treatment center. He is not here today.
He didn't file some additional brief, as sometimes happens when there's a Moffitt certification.
He did not.
That's
He was very happy with the brief I filed for him.
Excellent, thank you. Continue.
And the Moffitt disclosure attaches to the entire brief, not to any particular section of it.
Yes, Your Honor, it attaches to all 4 arguments in the brief. The first argument is whether the trial court erred by not giving an instruction that Mr. WAYLEIN is presumed not to be sexually dangerous. Although we don't grade levels of preservation, this error was very preserved. There was a motion in limine before trial, and I counted 6 instances in which counsel requested the instruction. It was not given.
You acknowledge in your brief it's not mandatory, right?
According to Wyatt Petitioner 1998 footnote 10, it is not constitutionally required. However, there's some good language in Doucette, Drayton, Medeiros, and Anderson that preceded that presumption of innocence and presumption of not sexually dangerous are instructions that should be given. However,
Help me, even in a criminal case, the instruction on presumption of innocence is not constitutionally required, right?
under In re Wyatt footnote 10, the Supreme Judicial Court stated in 1998 that the instruction of not sexually dangerous is not constitutional.
No, I'm asking about the presumption. So the argument, the way you framed it, is to equate the presumption of not sexually dangerous with the presumption of innocence. But as I understand it, even in a criminal case, an instruction on the presumption of innocence is not constitutionally required.
This state does not require a presumption of innocence, instruction to be given. However, in both criminal cases and sexually dangerous persons cases, individual jurors are asked, either in a panel or individually, depending on the preference of the court, whether they can abide by the law, which is that individuals are presumed to be innocent or not sexually dangerous. Mr. WAYLEIN is asking this court to revisit Wyatt and require that in all criminal cases and in all SDP cases that instruction be given. The second issue Mr. WAYLEIN has pressed regards his refusal to meet with experts. He didn't meet with any of the 2 Commonwealth experts or the 3 experts that he retained. The Commonwealth sought to introduce this evidence. He sought to exclude it. The judge excluded it. However, 3 different experts, Peretti and Bell for the Commonwealth and Plowd for the defense, all indicated that they do normally talk to.
That's 2, Peretti and Plowd, and that's what I saw from the briefing.
Peretti and Bell were for the Commonwealth. They both mentioned that they didn't speak with Mr. WAYLEIN and Plowd many times.
Did they say why?
They did not say why.
They did not say he refused.
No, they did not.
At least one of those was on cross by the defense counsel, right?
Yes. Dr. Plowd was a defense witness. On cross-examination, he said, I didn't talk to him. The court reminded defense counsel and Dr. Plowd not to mention it. Dr. Plowd mentioned it 3 or 4 times after that.
So the Commonwealth argues that the parties and the judge explicitly agreed that evidence that the expert did not interview the defendant was admissible. And they cite to transcript 145 to 147, which seems to support what they're saying. So what do you say to that?
I would simply point out that there was an agreement with the judge prior to trial. That would be...
The agreement was that not to say that he refused.
Right.
That didn't happen.
No, none of the 3 experts came out and said, Mr. WAYLEIN refused to meet with us. They simply said that Mr. WAYLEIN did not meet with us. There was no contemporaneous objection to the statements by defense counsel, and no curative instruction was sought, and neither party in closing argument mentioned this. And the only case I would point out is Commonwealth v. Mazzarino. The third issue.
Before you go there, is there a case that says that it is inadmissible in a SDP case to put in that the defendant refused to meet with the experts?
Commonwealth v. Mazzarino was a case in which a person similarly situated to my client argued that the jury should not hear about the refusal to meet with the experts, and the appeals court said that that is okay. The only difference between that
That
case...
means that is okay.
That it's okay. That there was no prejudice in that case to Mr. Mazzarino because there was no objection, and the attorney for Mr. Mazzarino at the trial level did his or her best to make use of it, to point out the fact that this was an incomplete evaluation because he was never actually interviewed by any of the experts. In this case, counsel for Mr. WAYLEIN at trial did not make use of the fact that he did not speak to any of the experts. It's something that perhaps the jury was expecting to hear, but they did not hear. The third issue is the introduction of the III. Mr. WAYLEIN was twice charged with failure to register as a sex offender in different states, Massachusetts Maine and Minnesota. Both were dismissed prior to trial. He has raised the issue that it should not have come in. We are mindful of General Law, Chapter 123A, 14C, which appears to allow basically any probation record. And the trial attorney at trial very forcefully...
Putting out-of-state records?
Well, the language says, the language says any adult or juvenile court or probation record. And the III index, which is a probation record, arguably falls under that rubric as a record. The question really that was presented by trial counsel and presented by Mr. WAYLEIN is, what possible relevance did it have that he was charged but not convicted of failure to register 8 years prior to a sexually dangerous persons trial? And we are mindful, of course, that the statute pretty plainly and clearly says that this record is admissible, as all probation records.
Was this framed as a 403? I mean, did somebody make an argument that says, look, Judge, I see the statute, but this is irrelevant, and even if it's marginally relevant, the prejudicial effect is too large?
Yes.
And you should redact it. Was that argued?
Trial counsel's argument was, in spite of this statute, this is completely irrelevant. The Commonwealth acknowledged that they don't have any reports, any grand jury minutes. So the argument before the trial court was, this is simply irrelevant. 2 8-year-old dismissed cases, regardless of what the statute says, and the statute clearly says that this is admissible, regardless of that, these don't matter. They can't possibly matter. In fact, the experts say, except for Dr. Peretti, the experts say they don't matter. How can we possibly gauge an individual's risk of reoffense and danger to the community based on 8-year-old dismissed charges? However, Dr. Peretti references them and says that they are evidence of his resistance to rules and supervision. So she found the Commonwealth's primary leading qualified examiner expert held these 2 dismissed charges against him as evidence that he is resistant to rules and supervision.
So she thought it was relevant.
She did.
Relevance is left largely to the discretion of the trial judge, right?
The standard of review for an evidentiary decision made by a trial judge would be abuse of discretion. In this case, there was a timely objection as well as a motion in limine, so we would ask that any error be considered for prejudicial error.
I've just looked through really quickly the argument, at least the portion that I may have been argued more than once, but I don't see any reference to prejudice or Rule 403. I don't see a balancing test mentioned. I see it argued more as just relevance and also a brief reference to the fact that it's out of state.
Well, I believe the relevance anytime we use the word relevance, we are implicitly invoking Rule 403. And in Section 5 of the brief, it argues why each of the errors are, in their own way and cumulatively, if taken together, demanding a new trial. Issue number 4 has to do with the closing argument of the Commonwealth. The Commonwealth mentions during closing argument that Dr. Perel and Dr. Peretti both testified that Mr. WAYLEIN remains a sexually dangerous person. This was a Section 12 case, not a Section 9 case, so of course there was no prior adjudication of sexual dangerousness. Prior to trial, though, there was a lot of conversation about whether and how to introduce evidence of prior hearings, probable cause hearings. So the Commonwealth was put on notice not to mention any prior findings of sexual dangerousness. Defense counsel at trial and Mr. WAYLEIN took this as a suggestion that there was a prior finding of sexual dangerousness. The judge and the prosecutor in the case believed that it was simply Dr. Bell and Peretti found him sexually dangerous initially and then found him sexually dangerous again. There was an objection. There was a curative instruction along with the general instruction given at the end of trial that openings and closings are not evidence.
So why was the curative instruction not enough? I mean, the judge said there was no evidence of that. This is the issue before you, and to the extent there was any comment or suggestion of that, you must disregard it.
The curative instruction says, and I have it bold here, there is no evidence of that. So there's no evidence of a prior adjudication of sexual dangerousness. And this is generally how judges in every type of case address this sort of thing, where an attorney says something that shouldn't be said, and there's no evidence of that. Mr. WAYLEIN believes the court should have said not just that there is no evidence of that, which of course lends to speculation, but should have told the jury under no uncertain terms, Mr. WAYLEIN has never been found sexually dangerous prior to today. This is his first trial. You are the first fact finders to be evaluating him. So Mr. WAYLEIN would ask that instead of simply there is no evidence of that, they should have been specifically and forcefully instructed that this was the first trial and there was no prior adjudication of sexual dangerousness.
So they got one curative instruction, no objection to the curative instruction, right?
No objection to the curative instruction.
Any request for anything further?
No. If there are no further questions, Mr. WAYLEIN and I would rest on our brief.
Thank you very much.
Thank you.
May it please the court, Kenneth Steinfeld for the Commonwealth. I just have 3 or 4 quick points I'd like to make in order of the arguments in the brief. The first is as to the instruction of presumption of non-STP. I think the distinction here is between the concept of a presumption of non-STP and an instruction on non-STP presumption. He's certainly entitled to have the jury told all of those other things that the Commonwealth has to prove beyond a reasonable doubt, that he's sexually dangerous on that day, that they're not to base their decision on anything other than the evidence and so forth, which effectively puts the meat on a presumption of instruction argument. So it's just a question of whether or not the defendant is entitled to instruction, not to have the jury told about the concept, which they certainly are, and here they certainly were. On the second argument, my brother stated that there was expert testimony that normally there's an interview, and that's not correct. None of the experts said that it was normal. There's testimony that said that sometimes I interview or sometimes there's an interview, but no one ever says whether or not that's the standard or not. Third, as to Justice Englander's...
Is there a case that says that it's admissible that an expert did not interview the person who's being alleged to be a sexually dangerous person?
Yes, it is certainly admissible that there was no interview.
So what's your best case for that?
Well, I don't know if I have one explicitly. I have to go back and take a look. The statute, as an expert, the expert is entitled to look at documents, and the jury is entitled to know what the expert bases his opinion on. And if that doesn't include an interview, then that's something that the jury is entitled to know so that they can
How about
judge
refusal?
his opinion. Well, there's no blanket prohibition on a refusal, and it can be a problem when the defendant speaks to some, but not all of them. And that's not the case here. So as was
But that's
pointed,
not an answer. The question is, can the Commonwealth ask for the defendant to appear and talk to the qualified examiners? And if the defendant refuses, can they put in the evidence that the defendant refused?
I think it's an open question as to which there is no definitive answer, but there's no case that says that there's a blanket prohibition on it, as far as I'm aware. But the parties here all agreed that it was not going to be placed into evidence, and it in fact was not. It also read that there was no 403 argument made at all about the dismissed charges. That was not part
Well,
of the
but
case
you know,
below.
yes, I agree. The words 403, more prejudicial than probative, they didn't come out. But counsel really pursued this line of argument. You know, the last thing that she said is the most telling, which is she wants to use these charges themselves as evidence that he did not register, without knowing anything else about why they were charged. I mean, what probative evidence was there in the fact that the charges had been made but were dismissed?
Well, several of the experts testified that it went to his general inability to follow rules, even though they had not been dismissed, and they told the jury each time that it had not been dismissed. So the experts did consider it when they formed their expert opinion. So,
I mean, the argument that's being made on the other side is essentially this. It has no probative value, and it is being used to attack one of the arguments that the defendant makes, which is, in terms of determining that this person is sexually dangerous, understand that if he's out in the public, he still is going to be subject to having to register as a sexually dangerous person. And the Commonwealth's evidence is, look, a couple of times he's been charged with not even bothering to do that. So that doesn't sound like a very good protection for you folk on the jury, right? And that's basically the way it's being used. And I think what the argument is where all you have is a dismissal, it has to be more prejudicial than probative because it has no probative value at all.
well, but then in that case, they would never be admissible, and it's quite clear
A dismissal would never be admissible, you mean?
Yes, if that argument holds, then it is never going to be admissible, which is clearly not the regime that has been set up. And
Why do you say that?
Because in each case, that will be true, that they will not.
No, but why do you say it's clearly not the regime that's been set up? I mean, you know, we get this question from time to time in various genres, you know, the sort of, is it relevant on the that this person was charged, but that nothing happened?
Well, by the regime, I mean 14C, which says that a probation record is admissible.
Sure, the probation record can come in.
Not just those that ended up in a conviction. And I would say
the statute says the probation record is admissible. Sure, the record comes in, and then someone says, but we're going to redact this because it has no probative value and it's more prejudicial than probative. What's wrong with that?
Well,
does the statute say you can't redact?
No, it does not. But the answer is, I think, cross-examination, which in this case brought out, the defense counsel did a very good job showing, well, what do you know about that? Nothing. So how can you take that into account? So to the extent there is any prejudice, undue or otherwise, it is overcome by the cross-examination. And I think that both of the Commonwealth's experts made pretty clear that they did not rely heavily on that because they didn't have that information. And a big part of counsel's argument below was that there should have been facts about those incidents themselves, which I think is sort of counterintuitive and not accurate, that the defendant would have been harmed by any further information. So the argument below was not
Well, we don't know that either way.
Right.
Because it could have been dismissed because they actually had the wrong guy or because he actually was registered.
Yes, those are both true, but he has never claimed.
We don't
that-
know the facts either way.
No, that's correct, we don't.
The burden was on the Commonwealth?
To show what?
The
Right.
admissibility and relevance, and that he's a sexually dangerous person?
Yes, of course. And the judge ruled, and counsel did not oppose on 403 grounds that it was not admissible. I'm not sure that I understand Your Honor's question.
Well, you're putting this forward as something that bears on his sexual dangerousness, and yet we know nothing about why the charges were dismissed. So let's, for example, if the charges were dismissed because they had the wrong guy, then how would that be relevant to his sexual dangerousness?
Well, because an expert in the field who is so qualified has determined that it is part of the constellation of information that that expert would take into account when determining whether or not he's STP. It's a battle of the experts. So I don't think that the Commonwealth has to show that show affirmatively that each thing that an expert actually takes into account does in fact go to what the expert says it does. We're not the experts are the experts. And the thorough cross-examination would and did bring that out in this case. Unless the members of the court have any further questions, I'd be happy to rest on my brief.
Well, I was curious.
Sure.
We rely on these expert opinions. When you've been here for many years, you see the same names over and over again. Does anybody track whether or not there's an empirical accuracy to these opinions?
Not that I'm aware of, no. But I can certainly make an inquiry and report back to the court. But no, I don't think that anyone has ever done a study or has looked at how often are they right and how often are they wrong. And in fact, Dr. Kriegman, one of the defense experts, testified at great length about how he thinks the whole endeavor is illegitimate and that it simply can't be done.
That's what prompted my question. I'm
Yes.
not asking you to
Yes.
report back, but we certainly have at least one person in this case who said, we're just making this up. That's what
Right, and there was evidence that he had a grudge to bear against the DOC, which had not made him a QE, which the prosecutor argued and that the jury had in front of them, and that was supported by the evidence. So that could cut either way. But there certainly are experts like Dr. Kriegman who believe that it's not an exact science or that it's not a science at all, but the legislature has determined that it is, that if you have certain qualifications, you can testify as an expert whether or not you think a person has a mental abnormality or a personality disorder that makes it likely that he will reoffend if not committed. So it's there, so it's not really for an expert to say, well, it shouldn't be because the legislature has said that it is. But no, there's no connection that I'm aware of or no proved connection that I'm aware of between experts, the number of experts who say yay and those who say nay. And of course, it is very, very hard to judge recidivism because we only find out when someone gets caught, which of course sort of skewers all of the statistics. So I don't think it's even possible to know really accurately how many are right and how many are wrong, because it's based solely on a subsequent arrest and conviction. Thank you very much.
Thank you. We'll take our morning recess.
All rise. We'll stand in a brief recess.
Yes. We're resuming the May 4th, 2023 sitting of the Appeals Court. Our fourth case on for today is 2022 P482, John Doe number 360651 versus the Sex Offender Registry Board. Mr. Gauthier, you are having a busy day today.
Busy day, Your Honor. Thank you for having me back. For the record, my name is Edward Gauthier. I'm appearing today on behalf of the plaintiff appellant John Doe. After an administrative hearing before the board, Mr. Doe is finally classified as a level 2 moderate risk sex offender, and this was a petitioner-initiated reclassification. He was originally found level 3 in 2017, but because he kept his nose clean for 3 years, he was statutorily allowed to petition for reclass, and he did so, and the board lowered his level to a moderate risk. I want to start off by letting the court know that we are not arguing that there are any factual findings in the hearing examiner's decision that are incorrect, and we are not quibbling with the application of any high-risk, risk-elevating, or risk-mitigating factors. A careful reading of the hearing examiner's decision indicates that all the factors are accounted for and all the facts are in the record.
That goes for factor 2 as well?
So factor 2 is repetitive and compulsive, and this court knows that part of factor 2 was struck down as unconstitutional. The part of it regarding elevated risk of reoffense or a high risk of reoffense based on having committed a sex offense and then committed a second sex offense.
Counsel, maybe I wasn't very clear in my question, but I thought you were saying you were not challenging the application of any risk factors. I thought I heard you say that.
Well, we are not challenging, so it's not so much as the application of a risk factor per se. So factor 38 is a catch-all factor that allows the board to consider essentially anything it wants to. And in this case, it applied repetitive sexual misconduct, which is under factor 2. It can't apply repetitive sexual misconduct under factor 2 because factor 2 does not apply.
So the board story, though, is we're not really backdooring factor 2 into factor 37. What we're really doing is saying that if he should reoffend, we're assessing the danger that he posed, and that basically we're therefore predicting that any future sex offenses would likely be against prepubescent children of either sex and could include multiple offending episodes with those children. And so that's why it was permissible. So what do you say to that?
I would accept that, except I know that that's not an honest rendering of events. I've been doing SOAR work for 15 years, and in those 15 years, the board has never mentioned repetitive conduct or multiple sex offenses in factor 38 catch-all. It started doing 37. It has never done that. What it has done is it's mentioned repetitive conduct in every case since the decision came down disallowing the use of repetitive conduct in factor 2. So the board uses repetitive in the catch-all factor only because it can't use repetitive in factor 2.
Oh, but is it inappropriate to use it there in the way that it's used? Actual assaults of victim 1 and then sexually assaulting another victim, concerning, and consider it as to petitioner's degree of dangerousness.
So this case is partially impounded, so we're not going to be using names.
No mention of compulsive in what Justice England just read, right?
Very true. They cut out the word compulsive, and they only use the word repetitive. And I can report to this court that I've handled maybe a dozen of these cases since factor 2 was struck down, and every case has repetitive in the catch-all factor.
Right, but that doesn't really answer my question. Is it inappropriate to use it as relevant to degree of dangerous? If there had only been one of those assaults, as opposed to many of them over a period of years, isn't that a difference that's relevant in considering degree of dangerousness?
I would argue that the fact that Doe in this case offended against 2 children who are 5 years old is amply covered by other factors, including high risk factor 3, which is adult with a child.
Talking about the fact that it's 2 different children. This statement is talking about with respect to one child it was repetitive, as if that is a fact relevant to degree of dangerousness.
If that were relevant to dangerousness above and beyond the other factors, it would itself be a factor. The factors in this case include multiple victims, include child victims. Obviously, if you have multiple victims, you've offended repetitively. You can't offend against multiple victims without also having repeated sexual offending. I understand that the factual finding that the misconduct in this case was repetitive may be supported by the record. I would simply argue that historically this seems to be a disingenuous workaround based on the finding of factor 2 being largely unconstitutional.
So you would say that if they offended against one child and then offended against another child, and both were just singular occasions, that that's repetitive?
That would be repetitive.
Or if they offended against one child 15 times over 3 years, and then against another child for a number of times, they're on the same footing.
The word would be, the word the board would use in each of, the word the board would now use in those in those circumstances would be repetitive. Whether it's 2 victims 2 times, 1 victim 5 times, 3 victims 1 time each, the board puts repetitive in the catch-all.
Right, but there's a difference between those things, right? Repetitive 1-to-1 and repetitive numerous times to numerous times. I mean, why wouldn't that fit in the catch-all?
So the board's regulatory factors, each and every one of them is supported by a research article or research articles showing an empirical validity of that factor. This is a brand new catch-all factor that the board uses in every case where we have more than one instance of sexual misconduct, and it's being put forth without any sort of empirical findings. It's just something that they came up with once factor 2 was struck down, and the board regulations went through an overhaul as a result of the SJC commenting that it was a long time before the regulations were made. So if they were going to have a regulation for repetitive that's not compulsive, there should have been a regulation.
I understand. So you're saying, just so I'm clear, that the factual distinctions are of no moment.
Excuse me, the factual distinction?
Factual distinctions between repetitive against one victim and repetitive against another victim versus a singular offense against one victim and a singular offense against another victim. No distinction worth commentary.
I have not seen empirical evidence that says that one versus the other would lead to an increased or decreased risk of reoffense or danger to the community.
Shouldn't be considered at all.
If there's nothing, factor 2, part of factor 2 was struck down because the board acknowledged that there was no science behind it, and there's never been science put forward behind their use of repetitive.
The board acknowledged that there was no science without having been confronted with the first one before committing the second.
Right. The science behind factor 2 is if an individual commits a sex offense and then the police come and the court comes and they sanction them, they've been sanctioned. If they continue to reoffend, that's a pretty big sign that their behavior is something that is outside of their control. The steps taken to...
But here you're talking about degree of dangerousness. And isn't it reasonable? I'm going to suggest, isn't it reasonable, independent of the social science, to conclude that someone who has performed a heinous act multiple times on a victim is more dangerous than someone who's only done it once?
It's very difficult to quantify. As you can see, and if you've handled many of these, it's extremely difficult to quantify danger. There's regulatory factors. Common sense is not a regulatory factor. The regulatory factors are, they're backed by science. And we can say, oh, I can just feel and I sense that a person who has done this is probably more dangerous than a person who's done this. But the board isn't guided by common sense. It's guided by science.
I surely hope that's not true. But
well, it's impossible to have judicial review of common sense.
I think you're saying in this area, common sense is not necessarily aligned with the scientific evidence, and that the board has to use scientifically based evidence.
Right.
So we throw common sense out the window.
No. No, I don't think so, but it's very hard to do administrative judicial review of a individual hearing examiner or a board's
But
common
here's the
sense.
question that's on my mind now, which I hadn't thought about entirely. You know, yes, we need science for all these factors. We have to look at the factors in evaluating whether this person fits high degree, moderate degree. But are we really saying that only social science can tell us how dangerous someone is? Because it seems to me when I read the cases on the issue of how dangerous they are, there is this sort of overlay of, sort of history and tradition of what crimes we think are more dangerous than others. Is this person violent? Or are you saying this all has to be in the factors, and if it's not in the factors, we can't think that way, that multiple times makes a person more dangerous to the community than only did it once?
I can tell this court that when I look at a case, I get a sense in my soul what the result is going to be without looking at the factors, because you just know. But for the purposes of the law, you can't just know. I would point out that in this case, my client was finally classified level 2 based on the board's assessment that he is presently a moderate risk of offending against prepubescent children. The 2 victims were 5. The problem is the 2 most robust indicators of a likelihood of reoffending are not reoffending and getting older. My client is more than 30 years older than he was when he offended, and he hasn't offended in 30 years. So to me, it seems like taking out a crystal ball 30 years later and saying, well, he sexually offended against 2 5-year-olds in the 80s when he was in his 20s. He's a moderate risk now because since then he drinks a lot and he gets into non-sexual trouble. It's hard with...
Non-sexual trouble?
The board, the hearing examiner found that there was insufficient evidence within the record to find as a matter of law for the purposes of this assessment process that he sexually reoffended. And I would argue that we are bound by her findings of fact on that.
She did consider the restraining orders against other numerous women, right?
Numerous, yes.
And so let's assume for the sake of discussion, we said that we agree that 37 shouldn't have applied. You still don't think there's enough to support a classification for level 2?
I think there's enough to support a finding, perhaps beyond a reasonable doubt, that Mr. Doe is an alcoholic, that he, up until the hearing, is a drinker, and that he is engaged in violence with adult women. I don't think there is enough to even find by preponderance of the evidence that he presents a moderate risk to children. The evidence that he poses a moderate risk to children is that he offended in the late 80s against 2 children, and he's a drunk who beats women. To me, that's crystal ball time to say, okay, we need to protect 5-year-olds because of what he did in the 80s.
There was something in the facts that talked about his interaction with the sisters of one of the 5-year-olds. Does that factor in going in when she was in the shower and inappropriately, I think, touching the other sister? Does that factor in at all? Both of them were older than 5.
I think we should be bound by the hearing examiner's factual determination that the evidence was insufficient to establish that as sexual misconduct. And I would ask the panel to contain its consideration of the facts to the facts that the hearing examiner found. So I would say no, that the only facts that should be considered regarding risk of reoffense and degree of danger are those that the hearing examiner explicitly found in her decision. Because she does state that she does not, it's not an oversight on her part. She explicitly says there's not enough evidence that this happened, so I am not going to consider it, and I would ask that this panel not consider it either. And I see that I'm down to my last 40 seconds, so if there are no further questions, Mr. Doe and I would rest on our brief.
Why do you say that the finding was that the petitioner had a risk of reoffense with respect to 5-year-olds. That's not what I just read. This says moderate risk to reoffend.
Well, in order for the board to establish the reasonable need for internet dissemination, it has to weigh my client's privacy interest against members of the community. And they have to be able to identify who needs to know that my client sexually offended. And in this case, the risk would be to the only 2 individuals he sexually offended against, which would be children. Thank you, Your Honors.
Thank you. We'll hear from the board.
If it pleases the court, David Chennai for the board. Talk about common sense. I can say that honestly that there's many people who know me, including my wife, who doubt my common sense at most days. But in this matter, I think that really, and I'm glad we're raising this issue about repetitive behavior, because it's becoming an issue in Superior Court. And I think the court is a little divided on it, because I think some of the judges are concerned that we're somehow backdooring Factor 2. Some of the judges are saying that we're probably applying it. So I think it's good to try to get this out in the open and get ahead of it. The reason why we're here is because in the past we never had to worry about whether repetitive indicated danger, because it was baked into repetitive and compulsive behavior the way the board interpreted it. Once we took out the first portion of repetitive and compulsive behavior, an individual who sexually offends against one victim, most likely a child, multiple times, that was baked into the original Factor 2. It no longer is. So how do you address that situation compared to other situations? And DOE 496501 in some ways kind of sets you in the direction of where the board went with this, is because that case says the board in determining dangerousness must show the extent of harm an individual will cause should he reoffend, and you look at his prior sex offending behavior to make that determination.
Right, and if that's what the hearing examiner said, then I think you would have a win here. But the problem is that the examiner basically says this was repetitive, and you've agreed that that by itself is not scientifically supported, at least in the case with Judge Wilkinson.
Correct.
So how can you show me, like actually let's go to the examiner's report and go to the language and tell me how this is okay. But like I want to know about the actual language, because I'm struggling with this one.
Well, I would say that the language was probably not expertly written. I think the intent of the hearing examiner was that because this individual sexually offended against a child multiple times over a 3-year period, that should he reoffend.
It doesn't say that.
But that's the issue. I think the hearing examiner addresses that in the dangerous section of the discussion, but in the application of the factor just mentions that she considered it in regard to his level of dangerousness. And I think that she tries to connect it up in the discussion section. And that, you know.
So what page would we look at for that?
That would be near the end. I think it's the second to last page of the hearing examiner's decision.
Well, the word repetitive only appears that one time on page 33. I think it only appears one time.
Let's pause for a minute. I mean, the hearing examiner really made this much more complicated by not finding there was enough about these basic, like, rapes of these other women, right? They had the authority, the discretion to say that they considered those, but this hearing examiner said, nope, I'm not considering that, right?
Correct.
And now that the hearing examiner has said, I'm not considering that, you agree with your learned colleague that we are not considering that?
Well, I think, you know, the sad part is we're all bound by the hearing examiner's decision. I myself wish I was the hearing examiner for this one case, because I would have considered, especially the 2 restraining orders, because each restraining order was issued, meaning that a judge found by probable cause those events occurred. And the hearing examiner could have considered them. I think the hearing examiner was very generous in not considering those as acts of sexual misconduct. I think she considered them as a pervasive pattern of this individual's behaviors and antisocial behaviors, but she didn't consider it as actual acts of sexual misconduct, which I think she could have under.
She didn't.
She didn't, and that's the problem with that. And I think because she didn't is why we're at a level 2 and not a level 3.
I was going to say, if she had accepted those, we'd be at a level 3.
And that's why I say I wish I was the hearing examiner, but unfortunately, they don't pay me to do that. But I think the issue is going to be,
So that's why I'm really pressing you on this, because as you probably know which ones of these decisions I have authored, and I had originally upheld Factor 2, and then the board admitted there was not scientific support for that in the Wilkinson's decision. So I want to know what language precisely in this hearing examiner's report you're relying on in the discussion, because I'm not seeing it. So I need you to tell me where it is.
well.
Or tell me it's not there.
It's not in there.
Thank you.
And I would never belabor a point that it's not within the record. All I'm pointing out is that the analysis for, and I think it's a bigger argument than this decision, no matter what you do with this decision, it's the argument about whether the board can consider an individual who commits multiple sex offenses against a child over a period of time, whether the hearing examiner can consider that when it goes to level of dangerousness. And I think you look at the fact, Doe 496501's wording about the extent of harm that an individual cause should he reoffend. I think it's common sense that if someone is going to be, and again, my common sense isn't one that should be relied on according to my family, but the reality is that it's common sense that if an individual sexually offends against a child once, that's one level of harm. If he continues to do it over multiple times over a period of time.
But we don't, that isn't the whole message here that and I think the cases say that common belief, I don't know whether it's common sense, but common belief is not actually consistent with what the scientific evidence establishes, and that for this to be constitutional, we have to be limited to the scientific evidence.
Well, here's the crazy part of this whole argument is that there are no studies about dangerousness. The legislature ordered the board to consider risk and danger. There is not a single study that discusses the danger an offender poses. All the discussions are about risk to reoffend. Even the most recent Hansen studies about desistance levels are all about risk. And in fact, those ones say that yes, the age and...
Say this?
Excuse me?
Does any case say this? Has this been acknowledged by the SJC that the underlying studies are all with respect to risk, not danger?
I haven't seen that, but I do have a case, and I think it's either Doe, back in 2006, it was either Doe 1211 or Doe 3844 that said the board doesn't necessarily need a study for every single one of its factors. Factor 37 is like a hybrid factor, in fact, that it looks at any information that goes to or pertains to the sex offending behavior. It doesn't have to be based on a study. It can be based on what the behavior is. In this case, and the hearing examiner was trying to articulate, when you sexually offend against a child multiple times, that there's an extra level of dangerousness there. And the reason why I say there's no study on dangerous...
Not as a matter of common sense, not as a matter of a study.
Right, because there are no studies. I've been doing this for 18 years. I've read almost every study there is. I've never seen one that talks specifically about danger. They're all about risk to reoffend. The problem the board has is that the legislature has said you need to find both risk and danger, and has ordered the board to promulgate regulations that take into account those two aspects.
That's what the legislature says, and then you have regs on it, and the SJC's cases have to do with studies as to risk. So as to danger, aren't we in a position where we can apply some traditional views of what is and is not more dangerous with respect to particular conduct?
That's exactly true. I mean, that's what the board is doing, and that's what a hearing examiner is doing in the decision. And the board has picked out certain things that show an elevated danger, such as a criminal record. An individual has a continuous problem with criminal record, well, it shows lawlessness and antisocial behavior. Studies do say that criminal behaviors can have indicate lawlessness and so antisocial behaviors. Not necessarily those studies are for sex offender recidivism. Those studies are more for criminal studies about criminal recidivism. And basically, that's what the board is doing, is looking at common sense approaches to dangerous. I know right now, going through the factors, they're reassessing each factor about whether or not the level of dangerousness should be in each factor, which factors it shouldn't be in, which ones it should be in, based on a common sense approach to it. Sure.
Imagine one of us is sitting down at our computer to write this decision, and we start the paragraph that says, we know that the hearing examiner was not backdooring factor 2 into factor 37 because, can you finish that sentence? Because that's what I'm struggling with.
Because looking at the decision of the hearing examiner, the intent of the hearing examiner was clear that she was focusing on the level of danger posed by an individual who has committed multiple sex offenses against one child over a 3-year period.
And that's the part where I'm like, where in the decision is that? Because that sounds great.
Right. But I think you can look at what the intent of the decision was. And I think even if you say in this case that you could actually say, look, Factor 37 can be applied in this way under these parameters. It wasn't done properly here, but based on all the evidence and the fact that they made him a 3 and a 2, it's harmless error. I think you can go that route with this case. I think it's important, though, that we set parameters as to the issue of 37 and the individual who commits this type of sex offending behavior, because it is becoming an issue in the Superior Court, and I think guidance on that matter will help everyone, including the board itself.
This is what we need, more work. Can I ask I didn't mean that, it's fine. Can I ask?
We like work.
Yeah, well, it's actually what we do.
I didn't hear anything, so.
Can I ask, all that the examiner said with respect to the 2 restraining orders was that she was not using it as evidence of prior sexual misconduct, which I think is basically a term of art, right? When you talk about the sexual misconduct at the beginning, here's the sexual misconduct I'm talking about. I'm not going to talk about these other allegations that were in the restraining orders. But it doesn't mean and I don't think the examiner did ignore the fact that there were 2 restraining orders, that these allegations had been made in connection with those restraining orders, right? That's still relevant and useful in the entire mix that we look at.
Correct. It shows a pervasive pattern of lawlessness and antisocial behavior. It's part of that whole equation. You know, one of the things that the fact...
We can't look at it as also having a sexual... With respect to your opponent's argument where he says, look, there's been no sexual offense for 30 years. We can't look at what happened in 2016 and 2013 as having a sexual component based on the allegations that were made?
Well, I can honestly tell you that I never would tell a court what they can do and what they can't do.
I'm asking you.
Yeah, I think that you're sitting in this situation de novo. You do have a right to make inferences in that manner. The hearing examiner didn't do that, and I think the hearing examiner erred in that, but it was to the benefit of the offender. If the hearing examiner had really considered those as...
Aren't we bound by that? She didn't find that.
Yeah, I guess you have to be bound by it.
Thank you.
I tried to wiggle around it, but you have to be bound by that. And I guess we have to be bound by the fact that she made him a 2 and not a 3.
Well, you could have appealed. Imagine.
So I see my time is running low. I think I've addressed the other issues on my brief. Unless there's any other questions, I'd be more than happy to rest on my brief.
Thank you very much. We understand. Our fifth and final case today is 2022 P910, Department of Children and Families versus Mother. It says and another, but I believe it's actually only Mother. This case also is impounded, so I would remind the attorneys and the panel to use pseudonyms or just mother, father, child, and not use the parties' names. And I understand that the department and the child are splitting time, 8 minutes for the department and 7 minutes for the child. I'm getting nods to that. When you're ready, counsel.
Good morning, Your Honors. May it please the Court. Victoria Aaron Carboni on behalf of Mother. This case involved a teenage mother with very little resources, very little family support, who herself had been involved with the department as a child and as an adolescent, whose child was removed from her care within 3 weeks of her birth. A mother who certainly faced challenges during this case, but a mother who loves her child. So although the record is clear that Mother did face struggles during the case, it does not support the conclusion that Mother was currently unfit at the time of trial or that she would struggle forever to be a fit parent. So the termination of her parental rights was an abuse of discretion. On appeal, Mother raises 3 arguments. Mother challenges the sufficiency of the evidence in this case. Mother challenges the participation of Father's trial counsel, particularly on day 5 of trial, after Father had stipulated to his current unfitness into the termination of his parental rights and after the entry of the decree terminating those rights, and finally to burden shifting as reflected in the judge's findings. As to the first issue, sufficiency, the judge relied heavily on findings related to Mother's substance use, her experience with domestic violence, and her mental health. The problem with the judge's reliance on the findings related to substance use is twofold. First, there was very minimal evidence of Mother's substance use on the record, and second, there was no nexus between that substance use and Mother's parenting. So yes, it is true that the department initially became involved with this family after receiving a 51A report alleging that the child was born substance exposed. Yes, Mother testified that she used marijuana briefly during the first 2 months of her pregnancy. Yes, the department identified substance use as a concern after the child was removed from Mother's care, and Mother's initial action plan included tasks requiring her to refrain from substance and alcohol abuse while caring for the child. Yes, Mother testified at trial that she engaged in underage drinking on 1 occasion. However, at no point did the department ask Mother to complete drug screens under any of her action plans. And after March 5th, 2019, more than 2 years before the first day of trial, the department included no tasks in Mother's action plans requiring her to refrain from substance use while caring for the child or even addressing substance use. And that's action plan effective 3/5/2019 at Record Appendix 18586, action plan effective 4/15/2020, Record Appendix 193, action plan effective 2/24/2021 at Record Appendix 100. Further, there is no evidence that Mother ever appeared to be under the influence at any visits while she was a child. And aside from Mother's admitted minimal use of marijuana during early pregnancy, no evidence showed any connection, any nexus to Mother's parenting.
I thought the child was born with marijuana in his system.
Yes, Your Honor. So Mother does not dispute.
Is that evidence that she used it more than in the first 2 months?
Yes, Your Honor, but the argument that the argument here is that given the length of time between the child's birth and the time of trial, there was no further evidence aside from testimony that Mom had engaged in underage drinking once.
I mean, the difficulty is, and I understand that this is your difficulty too, is that there are multiple issues that were identified by the judge as the basis for finding unfitness and terminating. And yes, substance abuse is referenced and domestic violence is referenced at some length, but what about total lack of housing, mental health issues not addressed, refusal to work with the department, which is, there's specific findings about that, refusing to engage in services, or refusing to help herself. What do we do with all that? I mean, even if we shear off substance abuse issues, even if we shear off domestic violence because there's been a restraining order against Father since 2018, isn't there a whole lot left?
No, and I think you've raised a number of issues, Your Honor, so I'll try and address them as much as
Sorry.
possible in
You
a
can
discreet
address whichever question you
So,
choose.
first, with respect to the housing instability issue, so yes, the judge did rely on the fact that mother struggled with housing, and related to that was some difficulty with communication with the department about accessing services. I believe there were some findings related to, mother missing interviews or missing intake appointments. And, that was certainly a struggle. But at the same time, the judge did find that mother had housing stability as of December. She did have stable housing. She did testify, I think, on the last day of trial that although she was not homeless, she needed to have a change in housing, so that is a fact, that needs to be addressed. But
Would you say at the conclusion of trial, mother did not have stable housing? Isn't that?
Your Honor, she did have housing. She was not.
At the conclusion of trial, your position is that mother had stable housing?
She had housing, and yes, she was going to experience a change in housing, but she did have housing at that time. She was not homeless at that time.
Did she have a
Stable
plan?
housing, stable housing is my question.
I would just say that she had housing at the conclusion of trial. So, aside from these issues, and some difficulty with accessing services, mother had very few little resources, very few family supports, and still was able to engage in services. Mother did engage in 2 domestic violence courses. The judge found that. She did engage in parenting classes. She did see a therapist. There were certain breaks in time where she didn't access the therapeutic services, but she did engage in those services as required by her action plans.
So the child's attorney basically argues that you're not identifying any fact under the findings of fact that were clearly erroneous, that you're really charging some statements that were made under the conclusions of law. Do you disagree with that?
I believe there are certain facts that, in the findings of facts, that mother would challenge and has challenged with respect to the domestic violence relationships, particularly, the finding that, or the conclusion that mother had an extensive history of domestic violence relationships. There were findings about a relationship with an individual who there was very little evidence.
Not use a name, but maybe K.A.?
K.A., yes, who there was very little evidence that mother was in a relationship with this individual, and even, if the court concluded
But
that was...
Does that really help you where she brought this person to visits and the person, K.A., was a level 3 sex offender?
Well, even if the court accepts that finding as, correct and true, that mother was in a relationship with this individual, there still remains the fact that there was no evidence that there was any sort of abusive behavior, any sort of abuse.
But the mother was I don't care about relationship, she was associating with and brought to the visitation with her child a level 3 sex offender.
Yes, but I still don't, I would still argue that it doesn't support the judge's finding that mother had extensive domestic or has an extensive domestic violence history or engaged in, extensive domestic violence relationships.
So you say that the mom participated and availed herself to some services and completed some classes and was in therapy, and there was a finding that she didn't benefit from those things. And I think you argue kind of that finding shifted the weight to mother to carry the burden. Did I understand that argument correctly?
So in part, yes. So I think that's related to the burden shifting argument. I think it's also...
Isn't it fair to look and see, while she may have engaged in these services, whether or not she's actually benefiting from them to help her as a parent?
Sure, but to that point, at least with respect to, the domestic violence issue, mother did engage in these 2 domestic violence courses. The judge, based on mother's trial testimony, didn't find that mother had benefited from those services, but at the same time, mother hadn't engaged with father in at least 3 years, in advance of trial, or approximately 3 years in advance of trial, with respect to, the restraining order. She had no contact with him. She extended the order. The last contact between mother and father was in September of 2020. That was his violation. So, in and of itself, mother's decision to distance herself from father in that way would certainly reflect that there was some benefit to those services that she engaged in.
So the child argues that an analysis of domestic violence and its impact on the child is required only when the judge is contemplating returning the child back to that situation. Do you have a case that says they're wrong about that?
No, I think under Vaughn, I think that would be correct. Mother's argument simply is that there was very minimal evidence of any witnessing of the domestic violence behavior by the child. There is a case that I came across that I intend to alert the court to in a 16L letter. It is a persuasive case. It's a Rule 23. It was published after my brief was filed. It's adoption of Harrison that pertains to this issue, at least with respect to the domestic violence. And I think, the nexus issue that child was challenging.
Wasn't there some language in there, though, that said unless the parent was the perpetrator and there was a restraining order taken out against mom, right? And whether visitation was being considered. Didn't both of those things apply? In determining whether or not I'm just trying to follow up on Judge Henry's question with respect to the application of mom's ability to engage in the services and whether or not it applied with respect to the domestic violence. I thought domestic violence was an issue if the parent was potentially the perpetrator of the domestic violence, which I think arguably applies here, right?
Such that it would, require those specific findings?
Yes.
I mean, at the end of the day, I think, the argument that I would advance is that the evidence that domestic violence persisted to be an issue for mom at the time of trial was very minimal given this period of time, this 3 years that she hadn't engaged in the relationship with father. She didn't engage in any other domestic violence relationships. She had a relationship with her boyfriend. There was one fact on the record indicating that there was, a yelling match between them. But,
At least responded to?
Yes, but since, from that I think it was January of 2020 until August of 2021 and through trial, there were no further incidents like that occurred. And, given that length of time, I would certainly, again, argue that mother did benefit from those, those domestic violence services and was able to keep herself, out of those types of relationships and certainly didn't demonstrate, an ongoing inability to distance herself from father, which the judge concluded in conclusion of Law 5. So this isn't, a case where, like in adoption of Jacob, the mom is showing a dependency upon and an inability to separate herself from her child's father, despite participation in counseling and domestic violence services, and who was still in a relationship with her father at the time of trial. Here, not only did mother separate herself, but she took those classes, those services, and she continued to keep her distance from father. I see that time is running short, so I will just go to the burden shifting argument. So the argument here is that the language that the trial judge used in reaching conclusions about mother's fitness here suggested, given the sheer number of times that the judge used words like failure to demonstrate various aspects of fitness, suggests that there was burden shifting here. Conclusion of Law 4, mother still has not shown, nor has mother shown. Mother was unable to demonstrate. Conclusion of Law 5, mother failed to demonstrate. Mother has not shown. Conclusion of Law 7, mother's inability to demonstrate. 8, mother has not shown. Mother did not demonstrate. 14, mother did not indicate. Mother has failed to. Instances like this, which go on, there are more, suggest that there was some burden shifting that went on in the judge's conclusions of law and in the findings, distinguishable from adoption of Terrence, in which there were only 2 instances of, the judge using the phrase demonstrate with respect to the issue of parental fitness and a parent's failure to demonstrate certain aspects of fitness. Given that my time is short, I will just close, again, that this case involved a teenage mother with very few resources and little family support. Whatever challenges she faced in this case were not so grave as to permit the conclusion that she could not provide minimally adequate care for her child, or should this court determine that such a conclusion was warranted, so grave as to permit the determination that mother's unfitness to care for her child would persist into the future. And with that, I rest on my brief. Thank you.
Thank you, counsel. I believe we'll hear from the department.
Good afternoon, Your Honors. William Cuddle for the Department of Children and Families. The department is asking this court to affirm the trial court's decision finding mother unfit, terminating her rights. I'd just like to point out to the court that this is a sad case for this mother. If you look at the findings that the court made and the very thoughtful findings, this child, or this mother, was living in an unstable life as a child. She actually says in one of the findings, the judge quoted saying her life was terrible.
So, but when the mother was 17 and without a home, did the department offer her a placement?
Yeah, Your Honor, I've been working for the department for a long time, and sometimes the department isn't always as responsive as it should be in offering services. This is not that case. The department made many efforts to meet with the mother, to try to get her housing, get her a bus pass, an ID. The department set up appointments for her to get housing. She refused to go. She didn't want to leave Lowell. She didn't take responsibility, and at trial was saying that the department's efforts, that the department didn't make the efforts that it said it did. The court explicitly did not credit mother's testimony. This is the part of the case that's very frustrating because, as Judge Englander pointed out earlier, the substance abuse issue, although an issue, is not the primary issue in this case of why mother's unfit. The issues of unfitness go to her failure to understand the impact of domestic violence on herself and on her child in the future, even after having training. Her not having housing. I mean, she hasn't had stable housing her whole life, Your Honor.
Let's focus on the domestic violence for a moment,
Sure.
because the judge said in the relationships plural, and yet it looks like we see two for sure relationships, and one was with the father, lots of domestic violence. The other one, we have one seemingly drunken shouting match that did not result in violence. Does that count for violence for purposes of domestic violence here?
I don't believe so. I think
Okay.
the judge, to be frank, I think the judge could have used the term relationship, the primary relationship. Although I'm not going to discount, the judge did find, and there is a concern that with the boyfriend in 2021, or the 2020, the intoxication, the public display.
There, that's Christopher?
Yes.
Okay.
But the real issue is that mother's relationship with the father, the court characterized as extensive. Mother didn't like that characterization, but it's actually accurate. The relationship lasted for approximately 2 years, but for 4 months, this relationship was marred with the domestic violence.
But she got a restraining order. I mean, in these cases that I've seen where there's a criticism for not distancing themselves, you don't see what we see here. She got a restraining order, and well, I have to be careful here. There is no finding that she was with father for 3 years, from 2018 up until the time of trial, right?
I'm not sure if that's completely accurate, Your Honor, but I would agree that the findings show that mother did not separate from father until October of 2018, I believe, 6 months after the child was removed from her care.
I think she got the restraining order, I believe, in November of 2018.
Yes.
It lasted for 3 years.
Right.
Well, to put a fine point on it, was the judge correct in finding that mother had shown an ongoing inability to distance herself from the father? Wasn't she distanced by the time of trial?
The judge focused on, yes, to answer your question, yes. The judge was focused on the fact that mother's decision-making showed that when she lost her child, she chose to stay with the father not engage in services, and give up her home with her own mother because of the relationship with the father that continued to be violent. That was the concern that the court had. And the court made that very clear in his conclusion, or in her conclusions of law.
Was there evidence of domestic violence in any of the other mother's other relationships?
Not that I know of, Your Honor, other than directly, no. I think the judge was concerned about the relationship with the boyfriend, Christopher, but there was no direct findings of domestic violence there. It was all related to the mother and the father.
Is there, so, I've looked through the evidence of whether there was a relationship between the mother and K.A.
Yes.
And then we can get to whether it was abusive. But the record is messy, but that seems like the judge took in evidence de bene, and then it was nobody moved to strike the evidence. So I guess, well, bottom line, what's the department's position about whether or not mother was in a dating relationship with K.A.?
Well, I can't answer that question, honestly, Your Honor. To be frank.
Well, you can't answer whether the record supports the judge's determination that it seems that the mother was in a dating relationship with K.A.
I think the record it was not challenged, so I would say that the court's finding stands.
Okay. Now, the mother argues in her brief that the judge ignored much of the parent's aide's testimony, and that therefore that was not an even-handed assessment of the evidence. What's the department's position on that?
Can you repeat that, Your Honor?
The mother is arguing in her brief that the judge basically ignored the positive testimony from the parent aides, and therefore this was not an even-handed assessment of the evidence.
I would disagree with that. The court took in 27 exhibits, heard from 8 witnesses. The court's in the best position, as this panel is very aware, to weigh all the evidence and consider what evidence it's going to rely on in making its findings. That's what happened in this case.
So the mother, as you've indicated, had some communication issues, and someone said, I think it might have been the mother, said that the department's position was that it is illegal for the department to contact a parent through Facebook or presumably some other social media. Is that the department's position?
I do not know the answer to that question, Your Honor. I read that too. I'm not familiar with that.
Okay.
I'm not going to say something that I can't support.
Do you agree with the child's argument that an analysis of the impact of domestic violence on the child is only required when the judge is contemplating returning the child to someone who's got a domestic violence history?
Yes. That's a custody issue. It was addressed in Lilith and Vaughn. This is not that case. The child was in a separate home, so the domestic violence is not an issue for making those type of findings. And just to get back to the domestic violence issue for a moment, if I could, the real issue here is that the court found that the mother, even after going to some services and going to a domestic violence class, which isn't always the case, as you're all well aware, that sometimes parents don't do anything. She did make an effort to take a course. She did take a parenting course. The judge found that the mother claimed and acknowledged that she didn't consider herself to be either a victim of or an aggressor of domestic violence. And the court, based on that testimony or information in the record from the mother, was sufficient for the court to find that she hadn't benefited from that type of treatment, which would then in turn put the child in danger, possibly in the future, and the court was not going to take that risk. And so with the combination of the domestic violence issues that mother didn't address sufficiently, her ongoing, I haven't even got to talk about. How much time do I have, Your Honor, just to be clear?
You're actually past time, 40 seconds, so we do
all right.
need you to wrap it up.
I'll wrap up quickly. The mother's struggles with her own mental health issue, which what the court found she didn't adequately address, and her housing issue were sufficient to really support the court's finding that mother cannot take care of this child now or in the future. And I'll rest on the rest of the department's brief.
I just have one other additional question. One of the classes that mom took, I recall that she completed the class. She said it was an easy class. but she couldn't really recall what the content of that class was. Was that one of the domestic violence classes, do you recall?
I think that might have been a parenting class, but I'm not 100% certain.
Thank you.
You know, to her credit, she did do some classes, but she did not benefit from those classes.
Thank you.
Thank
We'll
you.
hear from counsel for the child.
Good morning, Julie Gallup on behalf of the child. The child is asking that this court affirm the decision of the lower court terminating mother's parental rights and freeing the child up for adoption. I guess I would like to turn to the question regarding whether there needed to be findings about domestic violence. I think it was Justice Desmond with regard to visitation. I would say that it could be considered as part of, when ordering post-adoption, post-termination, post-adoption visits, that would be considered looking at whether or not it's in the child's best interest, and I believe you could kind of potentially fold in issues of domestic violence or the child's exposure to that in mother's custody when looking at that in the best interest context. But the child argues that the judge's findings were supported by record evidence and that my brother didn't speak to the issue of the father's counsel participating in the trial, so I guess I could talk about that. Looking at that, the cross-examination that father's counsel had participated in was not objected to until the 5th day of trial. And then when the objection was raised regarding relevance. Father's counsel explained that he was eliciting testimony to support the open adoption agreement, and that was the explanation that was given. The information was that his counsel elicited from the witness was reflected in other information exhibits or witness testimony, and I couldn't.
Not the fact that the two of them were showing up together. That was not reflected in findings or any other evidence.
Well, I guess I would say, yeah, that was where I was going, was that it did not make its way into the findings. So I would argue that the judge did not rely on that.
Except the judge does say that, and this is something your opponent picks up on as being problematic, the judge does say that, he finds that she has an inability to distance herself from the father. And without that evidence, there's no indication she was near the father since 2018.
This may be like my rigid, looking at, maybe perhaps I look too rigidly at the findings of fact and conclusions of law in looking at whether the information is a fact found or if it's kind of a summary of the information underneath the conclusions of law. So I looked at it more rigidly as though that was not actually what was found, and it was more an explanation to support the identified legal passages in that paragraph.
Yeah, I think judges sometimes call facts conclusions and conclusions facts.
I would.
Should be so.
I agree. I mean, that was kind of my rather rigid looking at things, but I would say that if that information, I believe, was not the basis for the unfitness finding with regard to the domestic violence, that there was other information that the judge could look at, including the fact that the child I believe there was a fact found about the mother was holding the child when there was an assault that occurred, and so that, setting aside the inability to distance herself from father, that the child herself had been present when violence had occurred. And again, that despite the fact that there had not been any recent incidents, or that there was no information presented as to recent incidents, that her testimony that she could not identify herself as a victim or as an aggressor, despite the fact that there were numerous findings about information where mother herself was aggressive or assaultive to father, that, you know, this issue with regard to her ongoing contact or inability to distance herself from father was not, I would say, like, kind of the underlying issue with regard to domestic violence.
Just go back to this, there's sort of this underlying assumption that if father didn't have the standing to ask the questions, then the questions somehow become a nullity, or anything that occurs as a result of I mean, why do we make that assumption, right? The father started the case appropriately, settled out in the middle. His counsel remained present for the next several days, right? Father had an interest. You're nodding, so as long as you keep nodding, I'm taking those as yeses.
Yeah. Yeah.
Father continued to have an interest because he was seeking at the end of this an open adoption award by the judge. Would that be part of the judge's order?
Yeah, so I believe it was kind of addressed in the transcript, but that he had executed, you know, that he had signed a stipulation identifying that he was unfit and agreeing to the termination of his parental rights. When that occurs, there is also typically another document, which is an open adoption agreement between the father and the pre-adoptive parent, agreeing to certain contact with the child after the adoption occurs, so that the testimony, so that was why his lawyer said, you know, basically, I want to make sure that the judge approves this open adoption agreement, even though.
Had that not occurred yet?
I believe there was kind of some discussion, so the judge entered the decree, but there was discussion, I believe, in the transcript that said that they still needed a notary, or they still needed the pre-adoptive parent to sign that agreement. But the judge said, I think in the transcript, that she had the intent of, she was going to approve it. I don't remember exactly where.
The agreement we're talking about is an agreement between the father and the pre-adoptive parent, saying, if we ultimately have our adoptive rights approved, then we will do X.
Yeah,
it's
I think.
not something that has to wait until parental rights are terminated and the adoption is approved.
My experience, my understanding has been that it is a document that occurs at the, you know, usually at the time of stipulation of unfitness. The judge would then approve the stipulation and the open adoption agreement. I believe the department might also be a party to that agreement, but I cannot, I don't want to misstate that. And so, I don't know if I answered your question.
I think you did.
Okay.
Thank you.
Does adoption of Malik leave some room for the parents' potential participation, notwithstanding the rights had already been terminated?
There was language in Malik that I could see where I wrote it, basically that said that the judge has discretion to permit, I'm trying to find that in my notes.
Court said the foregoing is not to say that a parent whose rights have been terminated may not in any circumstances be allowed to participate in a hearing to consider which of the two competing adoption plans in the child's best interest.
Yeah, so I thought, my reading of Malik was that the judge can permit a parent to continue to participate to consider an alternative plan than one which DCF is proposing, but not, you know, not that parent's plan, because they've already agreed that there is no plan. There may be circumstances where a parent may be allowed to participate in a hearing to consider which of the two competing adoption plans is in the child's best interest, and I can give you that site if you'd like.
Sure.
Yeah, so it's at 84 Mass App, 436, 440 to 441.
All right, you're over time, so we need to
Okay.
wrap up.
Thank you.
Thank you very much. That's the last case that's submitted. I just want to thank our court staff and clerks for your assistance today. Thank you very much.
All rise.